Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And we have a little bit of a stream for you today. Oh my gosh, can I get a haircut? Okay, we have a stream, and I have no idea how to do this. I have no idea how to do this stream. That's the big problem that I've got. Because this is a stream about a little girl who is caught in a nasty, nasty fight between two adults who have both acted in very inappropriate ways. And I believe both of them have leveraged this little girl to their advantage, both in court and in the press. And that alone makes this tough to talk about. That alone makes this a very difficult subject, because in a family law case, what you want is the child to be taken care of. Parents are going to fight and be terrible to each other, but they can take care of themselves. Children are not so simple. They're not able to take care of themselves. They're not able to take time for themselves. They have required obligations of the state through schooling, through potential court orders. They have, they're at the whim of the parents. They don't have the ability. They don't have the ability to get into a car and go somewhere private for a while. They don't have the ability to stay in their room. They have to at some level obey the people around them. They are subject. They are subject to them. And with that comes the trade that those people will keep them safe and keep their best interests at heart. And that doesn't appear to be happening. And that is why a family court ends up stepping in. But what happens when that family court doesn't treat the parents equally? What happens when that family court doesn't seem to have the best interest of the child at play? What happens when a case gets sensationalized by one party at first and then by another party second? These are some of the questions that we're going to have to ask in an ongoing case that, frankly, had fallen off my radar since we last talked about it, because it became very, very muddy. At first, the case looked pretty clear, and then it became very, very muddy. In this case, we have had two judges recuse themselves. In this case, we have had a judge share private medical information and offer to share court records with random people on the internet. In this case, we have one party blocked, forbidden by the court from discussing this on social media, thereby preventing their ability to raise funds in the way they were doing. In this case, we have the other party fully able to, with impunity, comment on social media, and has even hired a PR firm to help them do it. The reason I don't know how to do this live stream is because there is so much about this case. There's so much. Let me show you something. Oh my gosh. I'm going to show you just a snippet of documents. And these stopped in September of last year. Okay. Hold on. I got to make sure I have to be very careful this stream as well, for reasons which will become more apparent as we go on. Here we go. Here's one folder I have of documents related to this case. This is just through September 14th of last year. That's it. That's not counting everything from September 14th through today. So when I say, I don't know how to cover this, it would take years to do. Someone said in the chat, which was beautiful, they said, do it like any other case. It would take an immense amount of time to go through all of just those documents, which are now old news. They're done. They're not, some of those orders have been taken down. Some of those orders are still in effect. And it's hard to know which ones because this case involves children and the confidentiality of the children make document acquisition a little bit difficult. And then we have further muddying of the waters by the attorney for one of the parties, the attorney for Kelly Long. The attorney's name is Laura Elkind, I believe. Let me double check that. We're going to do this right. Laura Elkind of Laura Elkind Law, PLLC, who, when other people have talking about this case, Laura Elkind sent them cease and desist orders and then lied, saying that these documents were under seal, something that was not true, something that had to be pointed out to Laura Elkind. In her own case, she fraudulently stated that these documents were under seal, which they were not. In fact, any member of the public could go and procure these orders and procure these documents from the court in person. They just couldn't be acquired over the internet because of the sensitive nature of the documents involving children. So I have to be very careful. Apparently, and we'll go through some of this. Apparently, the mom is ready to pursue legal action against anyone who, quote unquote, invades the privacy of one of the minor children, which, when you have a PR firm issuing press releases about the minor child, I'm humbly suggesting that maybe that privacy issue isn't really the issue the mom is trying to address. I'll humbly suggest that the privacy issue might be what's called a pretext for wanting to control the narrative of this case. But I need to get a couple things out in the open, and I'm waiting because I know a few more people are going to filter into this stream as we rev up over the next couple minutes. In fact, a bunch are jumping in right now, and so I'm waiting to do my disclosures. I will be accused in this case because of this video. I'll be accused of favoring one party over the other. I will be accused of invading the privacy of children. I'll be accused of exploiting this matter, despite the fact that all parties involved have exploited this matter for their own personal benefit and to the detriment of the children. I will be accused of that, though I'm not doing so. In fact, getting back to where I began this tangent, this case had fallen off of my radar because It was so complicated. The issues were not clear. The good guys and bad guys were not so clear, and it became hard to follow with confidentiality. You're always having to like find a source for a document, someone who's down in the area who can grab it, and there are plenty of those, and the documents can be obtained, but I had other things to talk about over the past year. But that being said, what brought my attention back was a friend of mine. A friend of mine by the pseudonym of Kiwi Farms Ken Jennings, who decided to talk about this case, was threatened by the lawyer in this case to not talk about it. He actually complied fully with the cease and desist order. He did not discuss any of the documents that were listed, and yet, as a result of that, a group of horrific monsters found his private information. And I'm not going to say that Kelly Long's lawyer is the one that provided that private information, but I will humbly suggest that I believe that to be the case. I don't know if that's true. I find the timing of it very interesting. Again, I find the mother's employment of a PR firm in this case, which is supposed to not have a public presence, to be troubling. And the resources of said PR firm being employed are not outside of the question. I find the fact that that one place where those records could have been obtained was from the court file, which was allegedly sealed. Allegedly, though I've seen no sealing order that would prevent anyone other than the parties in this case who are properly before the court from disclosing or discussing it. What I find very interesting is the real possibility that a particular attorney utilizing the court system to access who had requested documents and then leaking that information might be a violation of the seal put on the court or put on that party by the court. What's interesting is Kiwi Farms Ken Jennings is not under jurisdiction of the Collin County court system in Texas. He's not a Texas resident. He has not entered an appearance on this case. He has not been subpoenaed into this case. He has not supplied an affidavit. He is not a witness in this case. He is merely an outside commentator, like any of us are. He's not subject to the jurisdiction of Collin County. But the person who is subject to the jurisdiction of Collin County and their ethical obligations to the state of Texas would be any lawyer participating in this case. And if they were to utilize access to the court records, the court transaction records, to find out who requested documents, and if they were to utilize those records and then release them, say to other parties, to take that information and contact a person's employer, or harass them at home, or call them on their phone unsolicited and with no purpose other than to harass, annoy, or molest, that lawyer may be in violation of their ethical responsibilities, may be in violation of a court order, and may be a pile of garbage. Something I could not imagine doing in any case that I've been party to. But again, that all hinges on if it was a lawyer in the case. Who knows? Who knows? That being said, regardless of whether or not a lawyer in the case did the disclosure, a particular lawyer in the case did send at least 2 cease and desists with fraudulent proclamations in them, things that lawyer should have known or did know at the time, in an attempt to threaten and stifle the speech of outside commentators, knowing that these commentators were not subject to the jurisdiction of Collin County courts. That did happen. That is not in question. And while that lawyer may or may not ever face discipline for it, it should be known that that happened. But that said, all of this sounds very one-sided. And so I think it's, well, let me finish the statement, which I started again so long ago. I had stopped covering this case until it came back on my radar because of what happened to my friend. And at some point during this show, I'm going to post his locals page. His locals page has the option to do a one-time tip. And I would encourage people who are moved by the plight of Kiwi Farms Ken Jennings to consider that. And if Ken is ever to finalize and publish a GoFundMe page, I will happily share that information and ask people to support it. Because what happened to Ken Jennings, if you are unaware, is that after his information was released, for the crime of merely talking about this case, a group of people, if you can call them that, contacted his employer, lied about what he was doing, lied about what he said, lied about violating a cease and desist order, just flat out lied to his employer with the purpose of having him terminated. And his employer, because employers are often embarrassing, caved and was terminated. And he was terminated. So, as he seeks to rebuild, hopefully something like a GoFundMe or whatever could provide him a little buffer time. Here, I'll get this pulled up. A little bit later, I'll discuss it right now. Suppose. Or we'll get this, okay, where are we? Get away. Nope. Go away. This one. Oh my. Too many windows. Here. All right, here we go. This is Ken's Counseling Couch tip page. This is where you can send a one-time tip. I'm going to drop that in the chat. Oh, don't worry, Spectre. I will be showing the cease and desist that you received on stream. We will also be playing a phone call that Spectre made to the 5th Court of Appeals in Texas to confirm that the cease and desist that was provided was not accurate. But now I think is the appropriate time to issue my disclosure, and disclaimer in this. I have never met Michael Long. I do not care about Michael Long in any personal sense. I do not favor Michael Long over Kelly Long in this case. I do not know which is the best custodial parent in this case. I do not know who is and isn't a danger to the children in this case. I have some ideas. I have some opinions. But as we have a case that is not transparently open to the public, we are stuck making those opinions on less than the full factual basis. I will hope to show you, as we have a court that is slanted towards one of the parties, we do not have a full factual basis in this case for that reason as well. So, there are times as I cover this, because I find the recent actions of Kelly Long and her counsel to be particularly troubling. Because of that, people will be tempted to say that I am acting as an agent for, an advocate for, or whatever for Michael Long. I am not. The guy might be the biggest dirtbag on the planet, and he seems to be in knowing violation of court orders at this time. And while I personally may sympathize as a parent with some of his reasoning, professionally and personally, I can also suggest, due to my experience as an attorney, my experience in family law as an attorney, representing clients, and my experience as a foster parent, that violating court orders in a custody battle, no matter what, is a grave and serious misstep. And that though the system may be imperfect, we have to entrust that the system will resolve itself correctly in the end. And I know that is a hard thing to say, and I understand as a parent why people wouldn't do it. But as an attorney, that's not only part of my ethical obligations, it is also part of my sort of legal commentary that parents, even if they feel they are completely justified, who end up violating those orders, oftentimes end up damaging their case and the relationship they will eventually get to have with their child more than if they had complied with the orders. It's not always true. In fact, we will see a particular point in this case where one of the parties flagrantly, openly, blatantly violated a court order specifically intended to remove the child from the presence of someone who is known to be a danger and may cause harm. They violated that order and the child was harmed by it, and yet the court did nothing. So, while I will suggest that Michael Long being in violation of court orders might not be the best play here, I will also humbly suggest that he could look at the court squarely in the eye and say, I learned it from watching you. But that being said, I am not on the side of Michael Long. I am on two sides in this case. Two sides in this case. I am on Sophie's side and the other children, period. Children are precious and need to be protected from the monsters that are out there. And I will always side with the children in these cases. The second side I'm on is one of fairness and justice. And that side is not being upheld in this case at all. As I will attempt in a very inapt and inept way to show you. As I was putting this stream together, I have, again, no idea how to go about doing this. So, with all of that disclaimer and preparation in place, we're going to read the existing early and large super chats, and then we'll get started. So, bear with me for one moment while I get okay. That being said, sorry. This has been one heck of a day for me. Where I was supposed to have a little bit more time to get this stuff organized, but life is real. Life is real. So let me get this pulled up. Okay. Funny Valentine says, are you planning to talk about the Activision lawsuit? Yes, not today. Oh, and just for anyone curious, there is no Vic Mignogna news tonight. Otherwise, we would be talking about that. This stream would be pushed to tomorrow. If we do not get through this subject sufficiently, I will continue to cover it. The fact, again, I had so little interest talking in this case until someone tried to stop people from talking about this case. Now that people don't want someone talking about this case, that has piqued my interest and curiosity. So we'll see how we get on this, and we'll see what information I am able to obtain about the case. We will talk more and more about it as things develop. Mexican Flash says, Nick, I don't know why people make fun of your nose. Personally, I like it, especially when it's at the right angle. It makes California 10 degrees cooler. Thank you. Thank you. Puggernaut says, I officially dubbed this season of Lawsplaining the Karen Crusades, courtesy of Drac. Also, can you cover the California lawsuit against Activision Blizz because the World of Warcraft team was too busy being horny dude bros instead of making a decent expansion? I will see. Again, yes, I plan on covering it. I want to cover it with some heavy hitters. So we'll see what we can do on that. There are a couple different people I would love to bring in to help me cover that case. Probably multiple of them, but there's some people that are in that world a little more than I am, and I would love to have their input. Not Applicable says, looks like all 10 soft hags showed up to downvote. Sop hags? I think it's sop hags. Showed up to downvote. That's fine. They can downvote this stream all they want. It won't make their lives any more fulfilling, and it won't make them any less disgusting, hideous monsters. I'm going to try and keep those things out of it, even though they're all now frantically deleting YouTube channels and stuff as oh, it looks like the doxing mirror got turned around, didn't it? Very unfortunate for you. But this stream is more about the case and less about the drama. Not Applicable says, why don't you peds consider rope or bridges? Strong questions. Bad Vibe says, our mates man the harpoons, we be hunting salty whale. Eldon Bainling says, rejoice, Nick, Dead Space is back. I didn't know it was gone. General Isimo says, just finished the Jennings stream with the snipers. Literally lolled at your, I don't know how the snipers will take Kool-Aid Man comment. No sympathy. If they're going to stream snipe the warp, they should bring an astropath. Harbinger 345 says, for your totally not a grift future disbarment fund. But hey, on the bright side, Guinness might send you the record for most disbarred lawyer ever. Well, we'll see. We'll see how that goes. Oh, and then there's one more case I need to make sure I have any Streamlabs stuff going on. The Pie Baker says, dear solar system of barren wombs, play fuck games when fuck prizes. Karma's a bitch. If she was easy, she'd be a slut like yourselves. That's horrifying. Thank you. Thank you for that. Okay. Well, let's just go ahead and start this off in the most horrible way possible, because reality is not always pleasant. So, whoops, I see that. We do have Reaver Barash says in Trump voice, just here to pass on Nova Zero's message. Nick is gay, the mods are gay, and chat is gay. Have a good night, gay boys. Fuck YouTube censorship. Yeah. Absolutely. Fuck all censorship. All of it. Nick, how did Kelly Long afford a PR firm? Oh, we're going to discuss that. We're going to discuss that too. Don't worry. It's all coming. Did you guys know that Michael is not allowed to have a social media GoFundMe? But Kelly Long has a trust fund managed by one of her attorneys and linked on, his website. So, again, fairness is a question in this case. And I'll show you. I'll show you that this is all here. I'll show it to you. Okay. Here we go. I figured it's best to go back to the beginning. The court ordered Michael Long and his attorneys to take down all instances of this video. Unfortunately for the court, which is stuck back in 1986, the internet exists and you cannot stop the signal. And no matter how much the Collin County Court and its extremely shady shenanigans in this case and others want to suppress the message, you can't stop the signal. This is a video that went viral, that sparked the public interest in this case. It is a video of young Sophie when she is supposed to be returning to her mother's custody. She is, I believe, at this point in the care of her maternal grandmother. And she is offering protestations. This is 1 minute long, and we'll just watch it. Whoops. Of course, I will boomer everything about this.
Leave me! Why don't you believe?
Who's touching you? That's okay. So who's touching you? No, I do want to know because I care about you. I do want to know. So who's touching you? Who's been touching you?
And mommy, what is it? And mommy, what does it have? And it always makes me feel bad about myself.
How does he touch you?
Leave me.
What does he do?
Like, touches it and scratches it. Because one time I woke up and there was blood in my underwear. I'm telling the truth.
I'm not, honey, I am not saying you're not.
And mommy visiting always makes me feel bad about myself, and I don't like the fighting or any of it. I'm not young, I'm tired of it.
Listen, if you thought
What? So, you want me to cut your shirt?
Yeah. Cut my
Okay,
shirt.
so, help me a little because I don't want to cut you. I don't.
God damn Facebook. What a shit platform that is. Okay, I know that was tough to listen to. Reduce volume if any more videos. Again, it's never mind. I'll do my best. So that is what kicked off this case on social media. And I have the backstory from testimony from the dad as to how we got to there, because that wasn't very clear how we got to there and what had been going on in the relationship and in the case leading up to that. What we got there was a little girl in distress, and that brought an outpouring of support. And the dad's justification for posting that initial video at the time was that he didn't know what else to do. He needed help. He needed help. And he got quite a bit of it. And this is the part where Michael Long's story gets really ugly. Michael Long opened up a GoFundMe and raised over $200,000 for Sophie, for the Sophie Fund. One moment. Okay. Raised over $200,000 for the Sophie Fund. I do not know what has happened to that money. I do not know if it was spent on attorneys. I don't know anything. However, the way Michael Long acted in his personal life following the receipt of that money is one of these stories of colossal stupidity for the ages. He was in a serious relationship with a woman named Courtney Chalmers, not to be confused with Super Nintendo Chalmers, but Courtney Chalmers at the time, and in the dumbest move possible, appears to have been unfaithful to her in their relationship at the height of this ongoing thing. I'm not going to comment on the wisdom of infidelity in general, but I will suggest that infidelity, while you are in a heated court dispute that has gone public, is a stupid, stupid move. A very stupid move. And considering, this is tying into where we started, considering that this case began with infidelity in a story that if you've been on the internet, you've heard it a million times, and I might even tell it just because of that. A story that started with the infidelity of the other partner ends up with infidelity on this partner, possibly being a huge impediment to his ability to litigate this case. Again, I am not a fan of Michael Long. I don't know the guy. I've never talked to him. Maybe he's great. Maybe he's just made some mistakes. Maybe he's a dirtbag. Maybe he's a pile of garbage. Don't know. Don't know. But he has definitely made some stupid choices. So, maybe it is time to go with how we got here. Maybe it is time to go just to how we got here, and who better to speak on that than the man himself. This starts 10. What the? Okay. Let's start with this story of Michael Long. So I was going to go through and redact the names of Michael Long's children. In some documents, they're redacted. Their initials, LL, JL, and SL, are redacted. Due to the public nature of this case, my strong stance against censorship, and the fact that these names are already out there, I'm not going to do that. I don't believe it's necessary, and I will not be speaking to any particular medical issues of these children that are sensitive and not already part of the vast public record. There's nothing that will come from their names that is not already public. I'm not going to tag them or anything like that. You know, it's just part of the story. And it's very unfortunate let me actually start with this. Let me start with this. I'm going to take a step back from what I was going to start with. And now we're going to do this instead. Because I think this is important to that last point. Are we? This is a story about this case from a while back. You may be familiar with the name of a particular judge in this case. The first judge in this case was Cynthia Wheelis. Cynthia Wheelis. She's married to another judge by the name of Ray Wheelis. Lyle Chipperson, why you got mods banning people if you're against censorship? No one is banned. People get timed out for spam. And that's it. So you can say whatever you want in this chat. And if mods are directed not to moderate or censor anyone's speech, they have one directive. They time out people for spam and tell them not to spam. That's it. That's it. So there's no, you can say whatever you want about me or anybody else. I don't care. I barely respect anybody. So what do I care what anybody says? Okay. So we have Collin County, Texas. 2 judges in this case at the beginning. Cynthia Wheelis and her husband, Ray Wheelis, is another judge. You may be familiar with Ray Wheelis. Ray Wheelis was the judge on the Save James case, also from about the same time, also from Collin County, Texas. We're not going to get into the Save James case too much, but let's just say it involved one parent encouraging and supporting and affecting the transition of a very young minor child, the gender transition, over the objection of another parent, and a judge in the case being Ray Wheelis. I encourage you to look into that case if you really, really want your knuckles bloody from smashing walls, because it's a little infuriating. Dax Terminax says, can't stay for the stream, but I will catch the replay tomorrow. Ken, I hope you remain in good spirits despite all this. And to the stream snipers, this could have all been avoided if you didn't go after Ken's job. Get bent. So there you go. Okay. So these judges have a little bit of infamy to them, and they have since recused themselves. However, not before Ray Wheelis appointed another judge who allegedly was not qualified to be a family court judge under the law when he was appointed in this case. But that's for later. Meanwhile, in Collin County, Texas, we have a case under Judge Ray Wheelis. Does anyone think this judge is following ethical conduct by doxing a 10-year-old child's medical records? This is the presiding judge of Collin County, Texas. If he is having these types of communications with members of the public, what type of ex parte communications were going on behind the scenes with the guardian ad litem and amicus attorney? So this is Ray Wheelis talking about the Sophie case. Here's what he says. He's friends with Lauren on Facebook. You're friends on Facebook with Ray Wheelis. Hi, Lauren. Thanks for accepting my friend request. I know you are interested in the Sophie Long case, and my wife was previously the judge in that case for a very short time. Ethics breached immediately. Immediately breached ethics. Do you have questions I can answer for you? Because while I'm just a mod in one of the groups, basically just crowd control, I actually am just some weirdo who loves true crime groups. Remember what I said about these people fetishizing the plight of this child. I don't know if this person is, but let's just say the advent of true crime and its extreme popularity amongst middle-aged women gives me pause. Was someone saying something about me? I'm no problem, and I'm 16 hours away. Ray responds, I understand. We are all concerned about Sophie. We want her protected. I have all the court documents if anyone wants to see them, including Sophie's medical records. These are public records. Anyone can get them from the courthouse. Just thought I would reach out. Tell your group members I will give them anything in the file they want to see. I believe in truth and transparency and holding someone responsible for the terrible pain the little girl is going through. So, if anyone involved in this case wants to talk about my use of the names of children whose names are very much already out there rather than their initials, you can say what you will. But the judge in this case was willing to disclose her medical records, something I haven't done, though I also am in possession of them as they were provided to me in that giant list of files that you guys have seen. And I had them back when this case was at first very big news and I was covering the case. I still chose not to do that. And I won't be divulging medical records today or on any other stream. All right, so we go now to the direct examination of Michael Long at a hearing that happened on July 14th of 2021. Is that judge liable for doing that? God, I hope so. By the way, judges and the courts are not really necessarily under HIPAA. HIPAA's a lot more narrow than people believe. But we're getting off on a tangent here. So this is his testimony from his July 14th hearing. And the reason I'm pulling this up is because this is a complete picture of how we got to Michael releasing the video. Even though the thing he's testifying about has nothing to do with any of this. He is asked to testify in this case as to why he did not bring Sophie Long into the courtroom, even though the judge told him he had to bring Sophie Long to the courtroom. Again, this is one of those violation of order things that is not a smart move. That's what he is supposed to be answering. He is represented pro se, so there are no questions. He is able to give his testimony in narrative format, which is what he does. And without having any direction, he starts from way back. But I think this is useful because I think this helps us understand the story prior to the release of that video. I'm going to try and read it as fast as possible. Bear with me. I think not what I wanted. Not what I wanted there either. Okay. I want to do this so I'm not looking off to the side the whole time. I got to rearrange something real quick. Kelly Long and I separated the night of Christmas 2014. Our relationship towards the last year, a little bit more, was quite tumultuous. There had been infidelity in the relationship while Kelly was out of town with a close friend and ex-colleague of mine. We eventually moved past it and had our third child, Lucas, patch things up and move to San Antonio. I was having some health conditions at the time with my face. I was eventually diagnosed with a condition called trigeminal neuralgia. And it was a pretty stressful time period because in the process, hold on, do you know how to spell that to the court reporter? He spells it. In the process of patching things up in our relationship, I agreed to leave my newly formed business behind in Arizona or attempt to do it remotely while Kelly had accepted a promotion in San Antonio. We moved and things were challenging. Lucas was premature. Danielle had come, her sister, Danielle is Kelly Long's sister, had come into the house, and our relationship, even though we had a honeymoon period, got challenging again. Kelly got pregnant a fourth time while we were in San Antonio, and when she started working in the same department as the person that she had stepped out on me in prior, ugly sentence, but she started working with the person whom she had had an affair with before. She said that she couldn't have the baby because the health risks were too great that she would potentially die, and so I agreed that abortion at that point was the only option. She aborted and shortly thereafter, within, I'd say, a month, requested that we have an open marriage. She wanted to date the guy that she had actually cheated on me with. So introspectively, attempting to move forward, I agreed to it for a time period. They dated. I was at home. You know where this story's going, right? This is a tale as old as the internet. I want an open relationship. Okay. This arrangement didn't work for her. Eventually, when it came time for me to go meet somebody, she became uncomfortable with it and asked for it not to happen. And so it stopped. Men, if she asks for an open relationship, the answer is no. Every single time. Repeat after me, every single time the answer is no. At that point, you have two options because your relationship is on life support. You either commit it to the streets or you work it out. The open relationship is never in your interest. That being said, I went out of town, came back, and found out that she had continued to engage in it, and the problems continued. So, she steps out, they patch it up. She says, I want an open relationship. He says, okay. She goes to the guy she stepped out with. He's like, well, that sucks, but all right. He goes to meet up with someone. She says, nope, you can't do that, only me. He's like, okay, so it's over then. Then he finds out nothing is over. Tale as old as time. Song as old as rhyme. Don't have an open relationship, guys, because trust me, you don't have one. That's just you giving permission to someone to cheat on you. All right. Fast forward to Christmas night. We had an argument, and it was the end of the road. I remember she told me distinctly that if you were a real man, I would never have cheated on you. It's always his fault. Right? Like, again, I only smile because this is the exact same story progression. This is a stereotypical story arc. I'd say it's archetypal. It's an archetypal progression. And that was the night I packed my bag and left with nothing. I had $200 that my mother gave me, my vehicle, and some of my belongings. I didn't have a place to stay, but I didn't want my children growing up in an environment where their parents were constantly at odds. I was unable to keep an attorney through the end of the divorce, which ended up finalizing in July, and I knew that I had to get back on my feet. I was under the impression from the lawyer that she had at the time that the best way to move forward would be to give her the rights to the children while I was out of state rebuilding. And so that's what I did. Always maintain your rights, men. And women, by the way. If you want the rights to your children, maintain them. Don't give them up temporarily. It's not a thing. Went to Arizona, rebuilt my business, and about 7 months later, I got contacted by a mutual friend of ours who had been watching the children for upwards of 2 to 3 weeks at a time that Kelly's drinking had gotten out of control, and she was concerned for the children's well-being and that I needed to return to Texas immediately. This is Natalie Tyler. I came back within a very short time period after packing everything up again with, again, the help of my family, and moved about 3/4 of a mile away from where she was living. After she found out that I came back and that I was there to at least split the load with her, help alleviate some of the burden and maybe some of the stress she was experiencing, she announced that she'd be taking a job in another town and leaving to Dallas. I'd found out that my parental rights were an issue at this point and that visitation was going to be a challenge. And so we went to court and we came to an agreement that we'd become joint managing conservators if I agreed that she could move to Dallas. She continued to date the person that she had started seeing while we were together. Everything after the initial hiccups started to calm down for a while. My wife, Courtney, who I'm going through a divorce with now, bad moves, very bad moves, became very close to the kids, which was a positive. And along the way, the children started displaying some behaviors that, at the very least, were concerning to us. One of which was Sophie came into the kitchen one day with a sugar cookie and said that the sugar cookie was so good, she wanted to put it in her... I will refrain. The other was Lucas when he was just out of diapers learning how to keep his privates in his underwear, and she was telling him to put it in his underwear, and she asked, where do your privates go? And he said, in his buttocks. Comments like this from little children don't feel right to us, and they shouldn't. They shouldn't feel right. That is, again, as a foster parent, as a family law attorney, both of those would be extremely, extremely concerning signs in any of these cases. It's the reality that children making statements like that, especially when they're far too young to really even understand the gravity of what that means, can indicate abuse. Doesn't mean that it does, and we don't know the particular context of how things were worded, how they sounded, what the kids were doing. I mean, sometimes kids talk about butts because they think butts are funny. That doesn't always mean that a child is being abused. However, they have concerns and they have the right to have concerns about that. And I'll admit, I do have a bit of a spiritual journey background. I've explored a lot of different avenues, and this is a side of me that Kelly and I just never saw eye to eye on. But fast forward to April of that year, Kelly had not let me talk to the children. I finally get to talk to them. We're at odds again and quite boisterous on the call, I'll admit it. And I was over the top, spiritually, kind of on purpose, because it was the only thing that seemed to put Kelly in a place where she just didn't understand that side of me. Well, her response was to call CPS on me and say that I was going to sacrifice my children over Easter weekend. Well, the next day, 2 armed police showed up to the front of the house with a CPS worker. And I got to sit with them for 3 hours and discussed what we actually did in our household and the fact that I didn't think my children were literal angels, but that in a way I thought they were angels, as are all of us. CPS ruled out the case immediately and the children were delivered that evening. So, this is, of course, slanted in favor of Michael. He is telling his own story. What he actually said, how heated that conversation got, we don't know. And it's important. It's important to remember that. This is from Michael's perspective. I do not endorse this perspective. I just think it's informative as to how things have developed from his perspective on why he is violating court orders and how he got to the point where he felt it necessary to bring his children into publicity. What his thought process was. Whether that thought process is correct or incorrect is not for me to decide. So, again, I know I'm going to get accused of all sorts of things because of this stream, because there's a bunch of people on particular sides of this that have very, very intense interest in it. I am and will continue to be neutral as possible on the parties. But this is a helpful look into his thought process. And if you don't think that's the case, then you don't understand how courts work, and you should probably be bludgeoned lovingly with some insulting remarks, and definitely not anything physical. At this point, between some of the behaviors that had gone on, the calling of CPS, the concerning statements from the children, and look, I didn't know all the right courses of action to take or who to call or what to do, and it wasn't like they were giving signs that they were so crazy over the top that I was convinced that there was something going on, but I had concerns as a father. We ended up in court because at this point, something needed to be shifted and something needed to be heard. Not only had there been the drinking issues ongoing in the past, they'd gone on when we were together, but they were going on with the kids, and now she was living without family in an isolated place. I couldn't. The situation didn't seem good. I didn't have a lot of money still. The business started growing, but we spent every penny we had to get a lawyer and get into court and hopefully have it heard. It was supposed to be 8 hours. Last minute, Kelly hired a lawyer that was the mother of the mayor of San Antonio, and she chatted with the judge, and suddenly the hearing was going to be 30 minutes per side. I got grilled about my spiritual background quite a bit. By the way, if you're ever planning on going through a custody dispute and you are religious, I would strongly suggest not being in a major metro area, and I say that without a single hint of irony. That is the damn truth. If you have any strong faith in your family, do not go through a custody dispute in a metro area anywhere in this country. I got grilled about my spiritual background quite a bit, and we never really got into the real meat of why we were there in the first place or why we'd brought it. At the end of it, I was sent to do a psychological evaluation, which I passed, and also to do a hair follicle test, which I passed, and things started to settle down. We went to mediation, came to an agreement, and for the time, I'd say things were peaceful, which was good. It was good for the kids. We first started having concerns, true concerns about what was potentially going on in Kelly's household in or around December. Well, back up. May of 2019, I got a call from a CPS investigator in Frisco who let me know that there'd been an investigation in her house, that she had found that there was negligence of the children, that there was domestic violence. Actually, I have the phone call recorded, and it was involving Jack actually going to school, and he's the one that told his teacher that his mom was thrown over a table and that she got hit. She had a black eye. There was drinking involved, all sorts of madness. And I feel even now that I was fair with Kelly, and we had a call, and she told me it was a big misunderstanding and that this isn't what happened. I gave her the benefit of the doubt. I have that call recorded too. Fast forward to January 2nd of 2020. I get a call from DFPS investigator Rita Kruger saying that there had been another investigation open again without my involvement or calling that involved Kelly calling in for refuge to DFPS. Obviously, this was concerning when I heard this, considering the context that I was given. I talked to Kelly that evening. She assured me that everything was great. She'd been going to counseling, and honestly, she sounded good on the phone too, and that she felt like her mental health was getting better. Her and Jake were awesome. Jake is Jacob Bellington. We will get to a point later, probably, I don't know if we'll get to it on this stream or not, but Jacob Bellington is the boyfriend who is alleged to have committed some of the sexual acts on the children. Jacob Bellington is also the boyfriend who, despite the mother being directly and explicitly ordered not to have any contact of the children with Jacob Bellington, drove the children allegedly to Jacob Bellington's house to ride in go-karts. And during the time that they were riding in go-karts, I believe it was Jack, the 7-year-old at the time, who was driving a go-kart, and it flipped over, and Jack had broken bones in his hands and wrists, which needed surgical repair, and that Kelly refused to disclose this, allegedly, to Michael for up to 48 hours because Kelly was knowingly in violation of a court order. And guess what discipline Kelly received from that? Fast forward to spring break after COVID stuff was starting. I had them for spring break, and I don't know if those in the court remember, but there was kind of an odd situation in the state of Texas with visitation time periods, and it came to the point where judges had to issue an order about when children would go back because school got delayed before the kids could start. Kelly had engaged her lawyer on the topic. Before I know it, the lawyers are going back and forth. She's angry because she wanted them back sooner, even though they weren't going to have to go to school. I wanted to keep them for the additional week because we had just moved out to the land where we live in South Texas. This came to a head at the exchange, and this was terribly alarming because Sophie, for the first time, absolutely positively did not want to go back to her mom or into Jake's care. Screaming, crying, it was bad. It was very, very extreme compared to anything I had seen. So much so that I started to have real suspicions about what actually was going on in the household. I called the CPS or DFPS investigator and told her my concerns, and I even sent her the video that we took, and she kind of pawned it off and acted like it wasn't a huge deal, just to monitor it, co-parent better. I thought, okay. Fast forward to the end of April 2020, and I found out during a phone call, a FaceTime with the kids, that I'm actually on the phone with Jack first, and he had his whole bag packed. A big one, all his Nerf guns, but they're not at their house, and I'm trying to figure out what's going on. And she's left the home to stay someplace else. She won't tell me where. Typically in co-parenting agreements, I don't know about theirs. I think I have it and could find it, but that would take me years to do on the fly. Typically in co-parenting agreements, there is a duty to inform the other parent of any overnight or 2 nights or 3 nights. There's usually some set amount of time of any time that they will be spending away from the home. And the reason is they have to know, the co-parent has to be able to contact the other parent if there's some sort of emergency. So they need to know roughly where they are. Or if they find out that the kids are in danger, they need to be able to know where to get to them, something like that. That may not have been at issue in this case. In Minnesota, it's pretty standard to have that there. I'm going to assume it's standard in Texas too, but I don't know. Finally, Sophie gets on the phone and she tells me, well, she actually grabs the phone and runs and tells me that there was a fight that was bigger than a fight, that Mr. Jake wasn't going to be coming there, that, well, she was kind of panting and running all around, and she tried to give me the address as to where they were at. She was frightened. She was scared. She was concerned. By the way, I believe Kelly is still somewhat involved with Jacob Bellington. I did the best I could to get the digits. Kelly had not disclosed where they were at. Finally figured it out. Actually had CPS or DFPS, go to visit. Kelly assured them everything was fine. Her and Jake had a problem because she thought he was cheating and that she had left the house for the benefit of the kids as to avoid any conflict, which is totally logical. However, then, 30 minutes after they left, she headed out of state and she went to Oklahoma. Again, typically this requires consent of the co-parent to leave the state with the children, because once you leave the state, things get very, very complicated when you have the children in custody. And during the next call with my children, I found out that they had left the state and gone to Jake Bellington's grandmother's house in Boise City, Oklahoma. And there was another male there by the name of Dan, Uncle Dan. On the following call, and Kelly would not report back where they had gone. She didn't want me to know. I get on the call with Sophie and she tells me the story about how her, Lucas, and Jack were walking around on the land because the grandmother has land out there. And there was a truck driving up and she didn't know who was in it, whether it was her mom, Uncle Dan, or whether it was Nana, the grandmother, which immediately told me they were left alone out on the land. And it was some other person that showed up and had salt rocks. And they were fluffy salt rocks, I think she described them as, and that, she was forced to lick them. And it all seemed kind of playful from her. But then Jack got on the phone, his eyes were so dilated, and he was acting so chaotic that, honestly, it immediately evoked some concerns that he had potentially consumed something. Courtney had done research on who Uncle Dan was and found out that he had a meth conviction from December prior, and that he was out there with them as well. Then we find out that Dan's watching them while they're out there riding, go like ATVs and all this stuff. So a lot of context there that, as a father who doesn't know where his children are, is concerning. Eventually figured out where they were at because Courtney was quite a researcher and sent a welfare check that went there at night. The trooper said everything's fine, the kids are sleeping, but I still had major concerns based on what I saw with Jack. So I got a hold of DFPS, who reached out to Kelly, and the first response I get back is essentially parroting what Kelly tells a lot of people, which is I have mental health conditions, and did not address the concerns. Fast forward, I didn't have my children for 63 days. COVID was going on, the business was struggling at this point, and we just got the kids. It had been 63 days. My mother and Courtney took Jack to a drug test facility in New Braunfels, which was the same as one that the court had ordered prior, and we had him do a zero-tolerance hair follicle exam. He tested positive for cocaine and marijuana about a week later. These children are under 10. Around the same time, Courtney had requested the 911 calls that had been going to the primary residence, and it was the first time in that week, the day before I got the drug test results, that I found out that during this entire period of time, there actually had been domestic violence situations going on. Really extreme phone calls going into the police where Kelly's reporting that Jake, has a felony assault record and that she buys him weapons because he can't buy them, that he took her gun and that she's with the kids in a room. She's scared. She's obviously scared. And part of me was scared for her because of how fearful she sounded over the phone. But the other part of me was quite disappointed that in that whole time period, even back in January when she had told me that she didn't call in for refuge, and I had told her at the end of that call, I hear you. I'm going to give you the benefit of the doubt. But if you ever find yourself in a situation like that where you're in a domestic violence situation, you can always call me. I don't care of our differences. I will go and help you get out of it. So there I was listening to the 911 calls and everything that happened and absolutely terrified for the fact that my kids had been in it. The next day I get the drug test results. I call DFPS and make a report. It takes about 7 hours for it to get back. I'm sorry, after 7 hours of not hearing back, Courtney, myself, and our child got in the car and drove to Dallas because we didn't know what else to do other than to then go to the police. We came up, got a call about 12 and a half hours after the original call from the supervisor at DFPS named Martin Lopez, who off the bat said, well, you can go and try and get your kids, but I don't think it's your visitation weekend. I said, I don't think you understand what's going on. My child tested positive for drugs. And he says, well, you can go try and get them, but it's not your protected time. I said, you do understand that the person she's living with has a drug conviction that's fairly recent in the Dallas area, and he has a DUI too, but that wasn't, and he says, oh, Jake doesn't have a criminal record. I'll never forget the way he said it. I said, sir, he does have a criminal record. We're looking at the mugshots right now. Long story short, he asked us to submit all the information, including the 911 calls, over to him. Mr. Routson, this is the attorney, and I'm going to take a brief pause from the transcript to talk about this person right now. Mr. Routson says, Your Honor, I'm going to object for a moment, if I may. If I may just ask more of a point of clarification, it was my understanding that you, at the beginning of Mr. Long's testimony, that you were asking him if he wanted to testify about your issuing a writ of attachment in an order or, based on the order to appear. My question isn't so much that whether he's testifying or not, as I don't see how that's connected to what he's saying right now. If Your Honor wants to give him the latitude, I'm fine. I thought we were here for the moment talking about whether he had a right to. So he's saying, and to his credit here, he's just saying, is this a proper testimony? Is this relevant? And the judge is going to say yes. So, but that's the preview. I want to go back to this. This goes all the way back to September 18 of 2020. And this is a critical time in the case. In September 18 of 2020, this is when the GoFundMe is peaking. Interest in the case is huge. And this is the time where the court issues, maybe I should... Hold on. I have to bring that up too. A particular order. But here we go. This is from August 31st. August 31st. This document contains sensitive data. I don't think it actually does. Or not the part I'm going to read. Let me see. I'm reviewing it real quick. I didn't see anything that concerning when I first read it, but yeah, no, there's nothing overly sensitive in this. It's just referring to the potential abuse that was going on. Okay. On this day, the court heard the amicus attorney's emergency motion for injunction prohibiting communications or other dissemination of information regarding the parties, children, participants, and subject matter of this case. So the guardian or the amicus attorney is the attorney who is appointed to act on behalf of the children in conjunction with the guardian ad litem. So you have an attorney, well, two attorneys technically, for Kelly Long, an attorney for Michael Long, and then the amicus attorney appointed by the court. And then the guardian ad litem is a non-attorney who is to represent the interests of the children. They conduct interviews with the children. They're supposed to represent their interests. One of the concerns that can happen in a family law case is that the judge is having, as stated in that article, ex parte communications with guardian ad litems, with amicus attorneys, or that those attorneys are improperly conferring with either of the parties. This is something that comes up quite a lot in heated custody cases, that these parties are not acting neutrally or acting in the best interest of the children, but they're acting in conjunction with another firm. I don't know if that's going on in this case. I do not know. I'm not making an allegation or an accusation. Either way, I'm merely bringing up some of the concerns that people have. That concern was expressed in that article we were looking at earlier. Let me also suggest that Collin County has ex parte communications between judge staff and attorneys more than is proper, because it's more than zero. This does happen in Collin County. I've spoken directly with people who have dealt with this in Collin County, that they have had judges in Collin County, maybe even judges that have been named in this case, conduct ex parte communications with parties prior to or outside of the record of a hearing. Ex parte communications, to clarify that, is where a judge or a judge's staff improperly contacts an attorney or an attorney's staff off of the record and outside of the knowledge of the other party. I've spoken to attorneys in Collin County who have had this happen. I can't say that that happened in this case. I cannot say that. I'm merely expressing that this is a concern of parties because of it. And because the severe nature of this, when it involves the custody rights to children, obviously you can see why this is a critically important thing to have hammered out. Whereas the above numbered and styled case is currently pending before the District Court of Collin County, Texas, upon consideration of the evidence presented and arguments of counsel, the court grants the motion. The court finds that petitioner, this is Michael Long, and his agents have created extensive publicity surrounding the case. The court finds that the out-of-court statements relating to the investigation and pretrial matters of this cause pose a serious and imminent threat to the children's emotional health and physical well-being, their rights to a fair trial, the ability of the court to maintain a fair and impartial jury, and to the fair administration of justice. The court finds that Michael Long and or his agents have created a hostile environment that incites violence against Kelly Long, the court, the attorneys, and professionals in the case, which is directly harmful to the children's physical and emotional well-being. Is it the children that you're worried about, Judge? That's what it is, right? You're worried about the children's well-being. The court finds that other, less restrictive means will not adequately protect the children's physical and emotional well-being and their fair rights to a fair trial and impartial jury. This is a term of art language on how you restrict the First Amendment. It has to pass strict scrutiny. The court at this point has justified, by saying so, that there is a compelling interest of the court to protect the health, safety, and well-being of the children. That is a compelling government interest, and that this is the least restrictive means possible because they're going to put something called a prior restraint on the speech of one of the parties. This is where this is extremely unfair, and ridiculous. One of the parties will be restrained from making public statements about this case. The other will not. But they have to justify a prior restraint on speech with strict scrutiny following the least restrictive means test. So that is why this is worded in the way it is. There's your little bit of legal education for the stream. It is ordered that Michael John Long, his attorneys, and agents are restrained and enjoined from the following acts: posting and or publicizing videos and photographs of the children, SL, JL, and LL who are the subjects of this suit on the internet/World Wide Web, social media, other media broadcast or publicity platforms, or causing the same to be posted or publicized. Posting and or publicizing statements or language that is intended to intimidate or may cause violence toward a party, witness, professional attorney, or judicial officers in this case. Intended to or may is extremely broad, by the way. Anything may cause something. Posting and or publicizing the names and personal information of the parties, witnesses, professionals, attorneys, and judicial officers in the suit. So that means that they cannot post the name Kelly Long, despite the fact that this is a person in the suit that is widely publicized already. Posting and or publicizing any statements allegedly made by a child related to abuse by any person associated with this suit. Making any libelous or slanderous statement regarding the parties, witnesses, professionals, attorneys, and judicial officers in this suit. This, of course, would have to be litigated, you would think. Michael John Long, his attorneys, and agents are ordered to remove all statements by a child who is subject of this suit. Video recordings, audio recordings, and photographs of the children related to or referring to any outcry of abuse by a child who is the subject of this suit from all internet websites, social media, and other publicity platforms within 12 hours of entry of this order until further order of the court. And this is an order by Cynthia Wheelis, who would later recuse herself. This person is no longer the presiding judge. Is now a guy named Michael Snipes, not the brother of Wesley Snipes. That is an important lead up to this. What? Not that one. Sorry. September 18th of 2020. This would be just 18 days later. Urgent fraud alert issued for Stand With Sophie GoFundMe page. The Routson Law Firm has announced a fraud alert for the viral Stand With Sophie GoFundMe page. Attorneys believe it intentionally misleads the public with false claims and has sparked dangerous calls for violence. Notice the source of this. This is important. The Routson Law Firm. Remember who was the attorney on the transcript that we just talked about? David Routson. So this press release from Intrado Global News is sourced from the law firm representing Kelly Long, right after Michael Long has been enjoined from doing this very thing. Dallas, Texas, September 18th, 2020. The Routson Law Firm it gets better, by the way. The Routson Law Firm has issued an immediate fraud alert for the viral Stand With Sophie GoFundMe page. The page has raised over $200,000 for 9-year-old Texas girl Sophie Long. Notice they don't censor her name. And father Michael Long, who alleges that Sophie is a victim of abuse of the supervision of her mother, Kelly Long. This would directly be against the order if Michael Long or his attorney or agent posted the same thing. This would violate the court order that was issued a mere 19 days prior. If Michael Long had his attorneys post the exact same thing, just in the first 2 paragraphs would be a violation of the order. Kelly Long has not yet spoken out publicly regarding the case. As a concerned mother, her foremost priority is to protect the safety and dignity of all 3 of her children, including Sophie. However, extensive evidence and documents provided by medical professionals, Child Protective Services, and the Frisco Police Department of Texas showed these claims against Kelly Long are entirely unfounded. Quote, "We have alerted the authorities and attorneys are doing everything they can to warn the public about the false nature of these claims. Michael Long's personal vendetta against his ex-wife has now escalated to dangerous levels," said a family spokesperson. Okay. I'm not going to read through all of this. And Spectre has a very good point, which we're going to bring up in a second. But I still think this is very, very important. Press contacts. Here we go. Press contacts. We will discuss the vacation of the order, but this is important. Press contacts. Kelsey Kintner, and Matthew Carswell of Red Banyan. What's Red Banyan? That. Holy shit, look at how sophisticated this website is. This looks expensive. Who is Red Banyan? Red Banyan, press the truth. What we do. Organizations dedicated to accomplishing their goals and delivering the right messages at the right time to those who matter most rely upon the nimble team at Red Banyan to press the truth. Press the Truth is Red Banyan's modern, proactive, assertive, and effective approach to communicating. We use it to seize the initiative, craft perceptions that become reality, influence public opinion, and protect the reputations and bottom lines of our partners. Let's take a look at where's the next thing here? Here we go. Just want to point out Routes and Law Firm PLLC. This is their webpage. Lawyers you'll swear by, not at. Family and business law with integrity, tenacity, and wisdom. What is the next thing on there? You guys can see it. Kelly Long Trust. Routes and Law Firm has established a financial trust for Kelly Long. 100% of the funds raised will go to assist Kelly and her children. Donate now. Donate with PayPal. All major credit cards are accepted. So, Kelly is allowed to have not a GoFundMe, but a trust fund promoted on the lawyer's website, a PR firm that is handling it. What's next? Oh, I closed it earlier. Just a second. I do have the order being vacated, but I'm having a issue pulling it up. Just a second. I've got a screenshot of it. For some reason, I'm having trouble pulling it up, but let me just pull it up here. So this is Here is what Spectre was referring to. That the order, the verbal order on August 31st, which temporarily sealed the case, was vacated and withdrawn on September 1st, 2020. All parties were emailed this order on September 1st, 2020. So that is there. So yeah, so the verbal order was memorialized here in the written order. Although there is a question I have about whether or not this written order, which is definitely not a verbal order, was vacated by the subsequent order. That's pretty interesting. Okay. So all of that to say, this is an important point to talk about this as well. I'm going to bring up some emails between Spectre and this attorney, Laura Elkind. So bear with me. I've got to open all these up. It's going to be a annoying sort of thing. So Laura Elkind is an attorney who represents Kelly Long. David Routson also represents Kelly Long. So, and they are from different firms. It's kind of, someone asked me how she afforded a PR firm. I don't know, but I know that not only does she have a PR firm, she also has two separate attorneys from different firms as well. Maybe she's got family help. I am not sure. Someone is lying about me in the chat. Well, get in line. I don't really care. People lie about me every day. Welcome to being online. Okay, so after. Oh, wait. Euclid the Mute says, my brain hurts. Maybe it's phantom pain. Aw. Okay, so after Kiwi Farms Ken Jennings received a cease and desist letter from Laura Elkind, Spectre was going to go live and talk about these documents, talk about this case in some way, not necessarily display the documents, but he wanted to cover his bases. And so he contacted the law office of Lauren Elkind and asked, because there was a cease and desist issued, he wanted to make sure he would not be in any sort of, I guess, trouble. Do I have the... Wait, you sent me even more of these. Hold on. I got to get these in the right order. 1 second. My apologies. I think this is the last one here. Woo, what a mess this is. All right. Here we go. So, maybe we should play. Well, we can do that in a little bit. Hold on. Let me get the context of this real quick. I want to make sure I get it right. So, yes, Spectre contacted the law office. The receptionist took down Spectre's email address. And then this is the response that Spectre received from the attorney, Laura Elkind. Okay? That's how this came about. Cease and desist. Petition for writ of mandamus. Michael and Kelly Long. Dear blank, I represent Kelly Long. It's censored out. I can't zoom in because of how stupid this thing is. You'll just have to listen to me read it. I represent Kelly Long. I understand you have questions regarding a petition for a writ of mandamus filed recently by Michael Long in the custody dispute with his ex-wife, Kelly. This petition is not part of the public record and is subject to a court sealing order. This is a lie, which we'll get to. Any hearing transcripts, testimony, and exhibits included in the petition were not and are not open or accessible to the public. Also, a lie. They're not open and accessible to the internet, but they are open and accessible to the public. The petition contains highly sensitive personal information about a private custody dispute involving 3 minor children. The disclosure of any information contained in the petition would be an invasion of privacy. This is also a lie. If you have the petition and want to avoid any legal exposure, you should delete this petition in its entirety. Here, Ms. Elkind is offering unsolicited legal advice to a potentially represented party or unrepresented party that is adverse to her, without a contravening statement that she is not his attorney and cannot provide him legal advice. As a layperson, Spectre, who is also lovably low IQ, that's a joke, cannot be expected as a layperson to understand that this is not his attorney and cannot give him legal advice. In fact, since they are threatening legal action against him if he does something, cannot ethically give him any legal advice at all. You should delete the petition in its entirety, including all attachments and exhibits, from all devices, and refrain from sharing or disclosing in any manner all or any part of the petition, including all attachments and exhibits and any information contained therein. Thank you, Laura Elkind. And this is very similar to the email that she sent to Kiwi Farms' Ken Jennings, which contained the same breaches of her ethical responsibilities. As a lawyer, if I were to send a cease and desist to someone, I am professionally obligated to inform them that I cannot answer legal questions. I cannot give them legal advice, and they must consult an attorney that is within the jurisdiction and licensed to practice law and is familiar with them to get those legal answers. I am basically required to do so, and Laura Elkind has failed to do so after lying twice, materially misrepresenting legal information about these documents. So, Spectre Report replies, Ms. Elkind, I'm interested in reading the sealing order issued by the court concerning this petition for writ of mandamus filed by Michael Long. As you are aware, an individual not a party to a case cannot be ordered to not share legally obtained documentation in which receipt was not enticed via illegal measures. Nice summary. Further, as someone outside the jurisdiction of the court, indeed outside of the state of Texas, the court has no authority to order me to do anything regarding this case. Also, mostly correct. It could, but it'd be an argument. You're generally right here. I would also point out that even if the petition is sealed, the order to seal would be accessible to the public to confirm this. Spectre is accurately stating the rules of civil procedure in Texas. As there is no order in this case from the Fifth Court of Appeals website available on Pacer or any other service, it wouldn't be available on Pacer, but it would be available directly from the Court of Appeals website, which there still is not an order sealing this case on the Court of Appeals website. or any other service for checking such a thing. I've requested to see this from a lawyer who is supposed to be representing a party to the case. I will also take a moment to point out that you have bolded a portion that appears to be legal advice specifically to draw attention to it. That could be viewed as an ethical violation as well, as you do not represent me in any capacity. The advice is unsolicited, and you are offering it to someone who could be an adversary in a legal proceeding, assuming what you are saying is true. As I said to your receptionist, Sarah, ? I would like to see the actual order to seal the paperwork signed by the judge, not a proposed order, the actual signed order. I await your reply. Thank you. This is a well-written Spectrum is a liar. Spectrum is probably the most accurate description of Spectre I've ever heard, but that doesn't make him a liar. So he has gone ahead and replied to Miss Elkin, and we'll get her reply on this in just a minute. Why do you think he's lying, Kaylee with the T? What about this? I mean, maybe he's lied on other things. I don't know. But what about this tells you that he's lying? Everything he said in that email was 100% accurate. And if you think otherwise, maybe you're being lied to by someone else. Wait a minute. Hold on one second here. Rats. In just a minute, we're going to have to take a break for a word from our sponsor. I picked the best shows to do these. Miss Elkind, I am replying to update you on a development. I spoke with Claudia, the deputy clerk of the court for the Fifth Court of Appeals where the writ was filed. I was informed by the clerk that there is no seal on the petition. Furthermore, the writ and associated filings are available to the public to obtain in person. They simply aren't available online because of certain sensitive data. I would like an explanation as to why you not only misrepresented the status of the petition, that it was sealed, that you threatened me with legal ramifications if I did not comply with your demands to delete or remove the items, knowing full well that what you said was false. As you are aware, this is a severe breach of ethical standards for a lawyer, and you should know that since you have over 25 years' experience in practicing law. I await your reply. Her response. My understanding was the Court of Appeals was aware of the sealing order issued by the trial court. Doesn't matter, by the way. That's a separate cause of action. That is a separate action in a separate court. Does Laura Elkin, do you think that the trial court can bind the appeals court? Of course she doesn't think this. Can bind the appeals court to a sealing order? It cannot. The appeals court would have to issue its own sealing order. I understand that the sealing order has now been filed with the Court of Appeals. Oh, has it? Whoops. The petition for writ of mandamus contains highly sensitive personal information about a private custody dispute involving 3 minor children. Hence my demand on behalf of my client, Kelly Long, that you refrain from disclosing this highly sensitive and private information. Thanks. Miss Elkind, I'm going to need to see a copy of this order signed by the trial court judge. You have to understand that you went from this is under seal and not available to the public and threatened me with legal ramifications to I was under the impression the appeals court knew about the trial court sealing this case, but now we have filed it, so my cease and desist applies. This seems to be something rather serious, as you have filed the same cease and desist, not just with me, but with another individual I'm familiar with. You've threatened legal action against people based on, at best, a lack of follow-through on your part in ensuring the seal was legitimately filed, and at worst, a downright lie because you knew the case was not under seal in the least. In any case, you had no order from the appeals court ordering the information be sealed when you sent the emails out. Second, I asked for a copy of this seal because most recent motion on sealing the case at the trial court level that I can find vacated the 31st August 2020 verbal order to seal the case. Laura Elkin says, give me a break. You're going to broadcast the most intimate private details about 3 little children? Have you no decency, sir? Let me take a moment to remind the court that they have already done this. They have already done this. Kelly Long, through her attorney and PR firm. By the way, all of you people out on the Sophie versus Michael, the Sophie Facebook groups, I know you're watching, or I know you'll see this at some point. For all of you out there, Kelly Long has a professional company with the purpose of influencing your decisions. Why do you think you went from supporting Michael to Kelly after Michael was muzzled? Why do you think the public narrative changed from pro-Michael to pro-Kelly, despite the fact that Kelly has violated numerous court orders, has consistently put the children in contact with Jake Bellington, whom she has been ordered to not have contact with the children? Why do you think the narrative shifted? I'm not going to tell you what to believe, but Kelly Long has hired someone whose literal profession it is to tell you what to believe. You are being manipulated and weaponized against good people talking neutrally about this case for the benefit of Kelly Long by a PR firm that she hired to do it. You want to call me a liar? I can document every single claim that I make. Kelly Long's documentation will be filtered through this. Red Banyan. You don't know banyan trees. Banyan trees are a great representation. They're massive trees. They don't grow tall, they grow out. They grow out extremely wide. They grow out so wide that their branches become too heavy, and they grow little support branches that will go down and root into the earth to support the weight of the branches that go out. Red Banyan is a national PR firm. Their logo and branding shows their clients that they're there to be an umbrella, to cover every issue, to support every issue, to cast a broad shadow over the truth in favor of their clients. The symbolism is obvious. The production is impressive. But reality is real. No matter how much someone pays to try and make it something different. And guess what? No one is paying me to tell you any of this. Except for Ridge Wallet, ridge.com/knows. Get a Ridge wallet, get a knife, get a Ridge backpack, which I have right here. Boom! Ridge is sponsoring this show. They have no idea what this is about, though. They are sponsoring this show, and I am happy to announce. That Ridge has extended their sponsorship of this channel through the end of the year because of you guys buying their stuff. Go get a Ridge wallet. Simplify your wallet. Simplify your life. Get yourself less back pain. Make yourself look cooler. Block a bullet maybe that's aimed at one of your pockets. I don't know. These things are pretty cool. Can they block bullets? I haven't tried. Maybe you can go to the hood and test it out. I don't know. What you do is you go to ridge.com/knows. /knows. Here it is. Boom. Nailed it. Ridge.com/knows. Use promo code knows. Get yourself 10% off. This is the best ad that Ridge ever paid for, and they probably hate it. But you should love it. Most importantly, and I mean, so most of this was a little bit of a joke. This is a real ad, by the way. This is a real ad. Most of this is a joke. But listen, the best part about Ridge is that they sponsor channels that speak to uncomfortable subjects frequently. They never tell us what to say. They never tell us what subjects we can and can't cover. Not at all. They support guys like me, Quartering, Yellow Flash, channels that you watch, people that you like, hopefully people that you trust. But they do it even when other people tell you not to. Like that stupid tea lady Kaylee with the T, who's out here trying to be, oh, he's sharing sealed records. Listen, lady, they can seal them all day. I'm not under jurisdiction of a Texas court. The people bound by the sealing of the records are the people who are in the suit. They cannot. I have a First Amendment right. They cannot abridge my First Amendment right. I'm not under their jurisdiction. I'm not under their power. I get to talk about things. We get to talk about this. I legally obtained these documents. I did not participate in any illegal procurement of the documents. And I will not be silenced by an attorney who lies to people through a cease and desist. And I want to be very clear. I broadcast openly that I would be covering these documents, and we're going to get to that mandamus petition that she's very scared of for some, I don't even know why. We're going to get to that mandamus petition. We're going to read that. I've got it. We're going to read it on stream. There's one party in this that she has not emailed a threatening letter to, and that party happens to be an attorney. I wonder why. That being said, we're going to get back to that email chain. Wasn't that the best ad you've ever seen? God, it was beautiful. I couldn't have even planned it that way. Here's your sealing order, but you're not getting my message. Sealing order or no sealing order, my client will consider all legal avenues available should you publicly disclose her and her children's private matters, including a lawsuit for invasion of privacy. The problem with this, of course, is that none of this has been private at all. Wait, what was that? That was good. Jalen Silestine says, it's not you, Ricada Law, because you're not a real lawyer. Oh, you're right. Kaylee with the T, Nick, who made Ken lose his jobs? The dumb women who called in and literally lied to his employer about him. That's who did. And if you can't accept that, you're literally stupid and you need help. And by help, I mean like you need assistance to eat a bowl of soup. Okay. Let's get back to this. Again, a lawsuit for invasion of privacy from these people would be absolutely preposterous. Absolutely preposterous, and she knows it. But listen to the language of her cease and desist here. My client will consider all legal avenues. That doesn't mean anything at all. That means nothing. Considering all legal avenues. If all legal avenues are zero, they've considered it. An invasion of privacy lawsuit for what? Publicly available documents that you didn't seal in time because of your failure? I'm sorry. Maybe Kelly Long needs to sue her attorney for malpractice for not getting the record sealed, for forgetting to file the documents. Spectre Report says, Miss Elkin, I had no intention of posting anything personal, including the names of the children, nor any medical information. My requests, you will notice, were specifically aimed at ascertaining the validity of the claim made by you in multiple cease and desist letters, including one you sent to me, when the intent of me contacting you was from the beginning that the petition is under seal from the court. Nothing more. At no point did I mention providing the document in full to anyone, nor make any claim that I would publicize anything. You made threats when I wanted an answer to a simple question. Is it under seal or not? Thank you. This is a message I got from my secretary, is that you wanted to know if a motion was under seal because you did not want to get in trouble talking about it. Ms. Elkin, my statement to her was, I cover legal issues on YouTube, and I'd like to talk about this motion. At no point did I say I was going to release the motion to the general public, merely talk about it in, say, a video. However, since I had seen emails purporting to be from you, claiming to be a cease and desist because it was under seal, I sought to make sure this was legitimate in my due diligence so I could cover that as well. I should have called you back and not just assumed you were another YouTuber wanting to publish the motion. That would be me. I don't want to. I'm going to. And I believe we were talking past each other. You focusing on the order and me focusing on the privacy issues. And the fact the sealing order is entered reflects the privacy interests the court is seeking to protect. If you were an attorney, you should have told me, are you? Spectre says, I am not a lawyer. No, the most I have done is pre-law in college, worked at base legal in the Marines. Had I been an attorney, I would have informed you out of courtesy. So there you go. There is the completed email exchange. Now, here is another thing to talk about. Here is a subsequent order sealing some of the documents issued on September 30th of 2020, which again cannot apply to the Fifth Court of Appeals documents. On order or on emergency motion to seal judicial proceedings and filings and prohibit internet posting. On September 30th, 2020, the court was presented with the emergency motion to seal judicial proceedings and filings and prohibit internet postings filed by guardian ad litem. The court, having reviewed said motion, at this time finds it is necessary to seal further judicial filings and hereby orders said filings to be sealed. Notice what the judge did not do in this order. The request was to seal judicial proceedings and filings and prohibit internet posting. They sealed the order, or sealed further judicial filings, and hereby orders said filings to be sealed. They do not prohibit internet posting, despite being explicitly asked to do so. They can't. They can't abridge free speech, so long as the orders were and the documents were legally obtained. There's a long history of First Amendment protection on this. You cannot stop a broadcaster from broadcasting legally obtained documents except when those documents and their possession outside of a security clearance are strictly liable as illegal, and that security clearance comes from the federal government with documents marked with a requirement for security clearance from the federal government. And even then, the broadcast and publication of those most sensitive documents cannot easily be abridged by the court, and certainly not a court who does not have jurisdiction over the parties involved. If anyone is telling you otherwise, they are lying to you, almost like they have a lawyer and a PR firm dedicated to lying to the public for the purpose of controlling the media narrative on this case. They can't do it. And if you've been lied to, I'm sorry. It'll settle in at some point, but it wasn't by me. It wasn't by Spectre. It wasn't by Ken Jennings. So ask yourself who lied to you. Go research it. Go research it. Sensitive government documents recorded illegally and then provided anonymously to broadcasters, so long as the broadcaster did not participate or induce the illegal recording or illegal production of the recordings, the broadcaster has a First Amendment right to cover and play in their entirety those recordings. It's long-standing First Amendment law. Again, go learn it. Don't let lawyers lie to you. Don't trust me. Go read up on the issue yourself. Sure, Spectre, I'll play the audio. Let's play the audio. All right, so this is audio between Spectre and the Fifth Court of Appeals clerk.
Is this for Michael Long?
Yes, it is.
Okay. The court has not ruled on the motion yet, if that's what you were.
Well, I have a question. I'm being told by a lawyer that is supposedly representing one of the parties, Kelly Long. She sent me a cease and desist because I'm in possession of the petition for writ of mandamus. She has sent me a cease and desist claiming that there is an order sealing the writ, the petition, as well as I think all documents related to it. Can you confirm if there is an order to seal it on file?
I don't see an order, and it's not sealed. It has sensitive information on there.
I'm
Notice what she said there. I don't see an order, and it's not sealed. It has sensitive information on there. Because it involves children in a custody dispute, it's going to automatically be restricted from internet access, not public access. You can go in and get the documents, which will be covered on this in just a second.
aware it has to deal with children. I'm very much aware of that. All
And
right.
that's the reason why. But let me transfer the call to our chief deputy clerk, because she's the one that handles all the mandamus cases, and she's the one that posted the document to the case.
All right. Excellent. Thank you very much.
Okay, please have your the mandamus case number ready. Okay?
I got that ready.
Okay, please hold.
Sure.
This is Claudia.
Hi. My name is. I am paying attention to a case that's been filed in the Court of Appeals for the Fifth Court of Appeals. And I received a cease and desist from a lawyer who is representing one of the parties in it. She claims that this specific petition for writ of mandamus is under seal. I didn't find anything on, already. I didn't find anything sealing it, but she said that there could be legal consequences. I just want to get from you, is there an order to seal this writ or not? I know there's sensitive information in the petition, but is there an order to seal it?
What's the appeal number?
05 TAC 21 TAC
Dash. Which one?
005 74 TAC Charlie Victor.
It's dash. What's wrong with you? Tack.
Okay, no, there is. This is not a sealed petition.
Okay.
It's just not posted to the web because it looks like there's sensitive data, like a child's birthday
Okay. Yeah.
and stuff, and so that's why it's not posted to the web. But it is. Anybody can come up here and get a copy of it because
Okay.
it's not sealed.
Okay. Excellent. Thank you very much. I guess this lawyer absolutely 100% lied to me.
Come on, Spectre. She can't talk about that.
I don't know about that. All I can do is tell you that it's not sealed. There hasn't been a motion to seal it. It's just not posted.
Well, the
to
lawyer
web.
specifically says that it's under a court-ordered seal, so.
Not here.
All right. Excellent. Thank you very much.
You're welcome.
You have a good day now.
You
Bye-bye.
too. Bye.
There we go. That is from Spectre doing some work there, finding out that this order is not sealed. Now, I will post something. I will show you something. Here is the case, by the way. Here is the case on this one. Since Kaylee with the T is suggesting that this is sealed, there is an order today received from the trial court. We don't know what that order says, but let's see what happens if we click on this. And I don't know how this is going to turn out. Doesn't look sealed to me. Considering I literally just clicked on it from the Fifth Court of Appeals. Notice that the petition was filed right here. The order is not publicly available. By the way, under the Texas Rules of Civil Procedure, and I would assume the Texas Rules of Appellate Procedure, an order sealing a case must be be publicly accessible and viewable. You cannot seal a case without an order that is publicly reviewable, sealing the case, because the public has a right to know if a case is sealed or not. Again, go research it. Don't take my word for it. It's right there. So now you will notice that the petition for the writ of mandamus is not available online. However, this case is not sealed. It may be sealed at some point, but an order received from the trial court does not mean that this case is sealed. Especially when we don't even know what that order says. So that being said, we will just have to wait and see. And unfortunately, I'm not a patient man. And so what I will do is we will now read the petition for the writ of mandamus. And this stream's going to be a little long tonight, guys. I do mildly apologize. Except that I never apologize. But as it has taken us a while to get to this document and to fully justify that, one, not only am I not bound by a court in Texas in a case in which I have not made an appearance, and in a case in which they do not have jurisdiction over me. Not only that, it also isn't sealed. So let's get going here. Identity of parties in counsel. We're going to skip this part. This part's boring. 1 second. Come on now. So he is asking for a writ of mandamus from the appeals court. A writ of mandamus is a writ. It's an order, basically, that goes from one government entity to another. And it is the Court of Appeals telling a particular other government entity, in this case, the trial court, that they have acted in a way that is so improper that it requires immediate intervention from the trial court or from the appeals court, and orders them to do something. And it is something that is issued when a party has no other legal recourse, and any further delay would cause significant harm to the party, significant and irreparable harm to the party. So these are very, very difficult to win. And the prospect of Michael winning this mandamus is not high, because any mandamus is low. Any mandamus prospect is low. Doesn't mean it won't happen. Maybe it will. Let's see what his complaints are. And again, you have to ask yourself why one party is so bent on this not being made public. The underlying suit arises out of cause number blah, 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 entitled In the Interest of SL, JL, and LL in the 417th District Court, Collin County, Texas. The underlying suit is a modification of an agreed order requesting managing conservatorship. Respondent is Judge Michael Snipes, sitting by assignment in the 417th Judicial District of Collin County, Texas. Respondent is Judge B. Stubblefield, sitting by assignment, abused his discretion by not conducting a hearing on petitioner's motion to disqualify/recuse, which they have to and didn't. Court has jurisdiction under Section 22.221 of the Texas Government Code. Issues presented: whether the trial court can order that sole managing conservatorship status of a child can be conferred upon an individual that has no standing and is not properly before the court. This is because the children have been ordered into custody of Danielle, who we talked about earlier. Danielle is not in Texas and is not before the court in this action. The court just picked someone who I believe is in like North Carolina or something and said, kids can go there. So the state of Texas is talking about sending the kids outside of its own jurisdiction, which is a terrible idea, in my opinion. Max Griff says, Nick, there's something I respect so much about you doing this. The fact that you looked these monsters in the eye and said, you want to come after Ken, come after me, see what happens. I live for this. Whether the court acted erroneously when it refused to allow for a contested hearing on a recusal motion. Whether Judge Snipes' appointment complied with Section 74.055B of the Texas Government Code. Whether the trial court acted improperly when it refused to allow petitioner to testify while acting in a pro se capacity and thus denying him the constitutional rights to due process. Very concerning. Whether the trial court erred when it conditioned the payment of $15,000 paid by Michael Long on whether petitioner has contact with the minor children made the basis of this suit. This is, again, directly against the statutes on file in Texas. Whether or not the court will side with Michael is a different question. But the statutes on point here make it pretty clear that you can't do what they did. At the hearings that were held on May 20th, 2021 and July 7th, 2021, there was no testimony whatsoever as to the costs or any related expenses associated with the case and or whether Michael Long had the ability to pay them. Whether guardian ad litem appointed for the children acted outside of her statutory role. Statement of facts. This case arises out of a petition for modification filed by Michael J. Long to obtain joint managing conservatorship with the exclusive right to determine primary residence of all three of the children, Sophie Long, Jack Long, and Lucas Long. This has been a very contentious case, and there have been numerous judges that have participated in the proceedings. Michael Long petitioned the court for primary conservatorship based on a number of reasons, namely sexual abuse allegations by Sophie Long against Kelly Long's boyfriend, Jacob Bellington, a positive drug test on Jack, one of the minor children, and a number of calls to 911 by Kelly Long while the children were in her care. But prior petitioners' requests to modify, the parties were co-parenting effectively, and there were little to no disputes between the two with regard to parenting of the children. The case was originally before Judge Wheelis, who voluntarily recused herself and requested that her husband, Ray Wheelis, the presiding judge of the administrative region, to appoint Judge Snipes to hear the matter in Cullen County. Whether the trial court can order that a sole managing conservatorship status be conferred upon an individual that has no standing that is not properly before the court. This court has authority to grant mandamus relief if the relator can demonstrate that he has no other adequate legal remedy, and under the relevant facts and law, the act sought to be compelled is purely ministerial. An act is ministerial if the relator has a clear right to the relief sought. That is, the relief sought must be clear and indisputable, such as that its merits are beyond dispute, with nothing left to the exercise of discernment or judgment. If an adequate remedy at law is available in the form of an appeal, it is an abuse of discretion for this court to grant mandamus relief. In its May 20th, 2021 order, signed on July 7th, 2021, the trial court erroneously named Danielle Hamlin as sole managing conservator for one of the children, SL, even though she is not properly before the court, has met no standing requirement delineated by statute to intervene, has had limited contact with the minor child, and as such, the trial court has no authority to direct her in any manner. The trial court went further and ordered that Ms. Hamlin have all of the exclusive rights and duties associated with the minor child. This erroneous ruling essentially precludes both parties / biological parents from any decision-making authority regarding their child in favor of an individual that has no standing and is not properly before the court. Therefore, if Ms. Hamlin acts in the capacity in which she has been appointed, neither of the parties that are properly before the court or the court will have any authority to enforce any duty, right, or obligation in the care of their biological child, and the court will not have authority to require any such action on behalf of the non-party. Here's the problem with Danielle Hamlin. Let's get to the first and primary problem. Danielle Hamlin is the sister of Kelly Long, who is ordered to not have access to the children. The sister of a party ordered not to have access is an automatic problem. Now, what makes it a bigger problem is that it is a sister outside of the jurisdiction of Texas being granted access, being granted sole managerial custody, sole physical custody on a temporary basis. That means that doctors' decisions, school decisions, all of that, all of these decisions involving the minor child being placed in this person's care. who is outside of the court's ability to enforce a court order upon them. Will Michael win on this? I don't know. But let's say he doesn't win on this. If he doesn't win on this, then Sophie goes to Danielle Hamlin by court order. And then let's say the court demands that Danielle Hamlin produce Sophie in court on a particular date. But they can't, because Danielle is not under jurisdiction of Collin County. They can't do it. Whether the court acted erroneously when it refused to allow for a contested hearing on a recusal and or disqualification motion. Whether Judge Snipes' appointment complied with 74055B of the Texas Government Code. After Judge Cynthia Willis recused herself in this matter, and by the way, for the person who keeps saying over and over that this is somehow compromising the privacy rights of the child, you tell me in this order where. Or in this petition where. After Judge Cynthia Willis recused herself in this matter, Judge Ray Willis appointed Judge Michael Snipes. At the time of this appointment, Judge Ray Willis had been active on social media, including sharing the child Sophie Long's medical records with a number of individuals on the same media platform. Remember, Judge Ray Willis used his wife's position as judge as justification to share these documents to people on Facebook. Before recusing himself, he issues the appointment of Judge Michael Snipes. He should have recused himself from the decision to appoint Michael Snipes in the first place. He should not have made this decision. He is compromised. His wife was compromised. She had already recused herself. Then she's like, Hubbo, will you do this? And he's like, yeah, right after I send these thoughts, some stuff on Facebook. I'm sorry, what? Subsequent to that, Judge Willis immediately recused himself from the case once petition filed a motion requesting the same. At the time of his appointment, Judge Michael Snipes was clearly not qualified for the appointment to a highly complex family law matter. Trial court clearly acted erroneously by refusing to conduct a hearing on petitioner's motion to recuse and or disqualify. Upon presentation of the motion, Judge Michael Snipes declined to recuse or disqualify himself, thus requiring Judge Stubblefield to conduct a hearing on the motion to recuse/disqualify. When Judge Stubblefield was duly appointed to preside over petitioner's request to recuse and or disqualify Judge Snipes, he summarily issued an order on the 16th day of June 2021, making several findings in the order, but refused to conduct an evidentiary hearing. This is clearly an erroneous ruling. In R.E. Eduardo Chavez. First of all, Axe Lion says you have a glowy PR agent in your chat, Nick. Oh, it's fine. I'm not scared of PR firms. I'm not scared of lawyers, and I'm certainly not scared of a bunch of fat, loveless women on the internet. This is clearly an erroneous ruling. In R.E. Eduardo Chavez, the El Paso Court of Appeals stated, unlike the complaining party in R.E. Union Pacific Resources, the relators in the present case, like the complaining party in Woodard versus Woodard, did not have their recusal motions properly denied after a hearing before an assigned judge. The language of Rule 18AF suggests to this court that the rule addresses those instances where a recusal motion was properly denied, but does not expressly provide an adequate remedy where a trial judge takes no action or inappropriate action on a recusal motion that is in procedural compliance or denies that motion essentially on its merits without referral or even a hearing. Oops. The San Antonio Court of Appeals discussed this distinction in its opinion in R.E. Flores. In its review of the in R.E. Union Pacific Resources, the court noted that in R.E. Union Pacific involved the denial of a motion to recuse rather than a complaint for failure to comply with Rule 18C. In R.E. Flores, based in part on this reasoning, the court determined that it had mandamus authority. See also Vigiano versus the Honorable Don R. Emerson. finding no remedy by appeal under circumstances where trial judge failed to either refer or recuse, such that the motion could neither be granted nor denied. The differences between the facts in Union Pacific, a case involving a clear denial of a motion to recuse by the assigned judge, compares to the situation in which relators find themselves, suggesting to this court that the Woodard versus Woodard decision interpreted in Union Pacific much more broadly than was warranted in the case and creates a bewildering effect. Further, it is clear that the statute requires the following: summary denial for noncompliance. Motion to recuse. A motion to recuse that does not comply with this rule may be denied without an oral hearing. The order must state the nature of the noncompliance. Even if the motion is amended to correct that stated noncompliance, the motion will count for purposes of determining whether a tertiary recusal motion has been filed under the Civil Practice and Remedies Code. Motion to disqualify. A motion to disqualify may not be denied on the ground that it was not filed or served in compliance with this rule. Back to the case. Judge Stubblefield specified in his order that there were no facts are set forth therein which might lead a person of reasonable sensibility to conclude that Judge Snipes might harbor some bias or prejudice against any party to the current matter pending before the court, which would impair his deliberative function. This is not the standard on a motion to disqualify as stated above. Further, the statute requires that the disqualify must be heard as soon as practicable, and this was clearly not done. In addition, the statute clearly allows a motion to disqualify to be reviewed by mandamus. Appellate review. On order to recuse. On motion to recuse. Denying motion. An order denied and a motion to recuse may be reviewed only for abuse of discretion on appeal from the final judgment. Granting motion. Order granting a motion to recuse is final, cannot be reviewed by appeal, mandamus, or otherwise. Order on motion to disqualify. An order granting or denying a motion to disqualify may be reviewed by mandamus and may be appealed in accordance with other law. So he filed a motion to recuse and disqualify. Whether Judge Snipes' appointment complied with Section 74.055 of the Texas Government Code. Judge Snipes was clearly not qualified to receive the appointment to preside over a family law matter when he received the initial appointment by Judge Wheelis, who subsequently recused himself on the matter. As of June 22, 2021, Judge Snipes had only one specialty that was listed. His specialty was only as a criminal judge at the time of his appointment. On or about June 22, 2021, his specialty was changed to reflect that he had a specialty in family law and could preside over family law matters. It is important to note that this specialty was not changed until after petitioner filed a motion to recuse. The requirements necessary for an appointment are delineated in Texas Government Code 74.055 as set out below. List of retired and former judges subject to assignment. Each presiding judge shall maintain a list of retired and former judges who meet the requirements of this section. The presiding judge shall divide the list into area specialties of criminal, civil, or domestic relations cases. A retired or former judge may only be assigned to a case in the judge's area of specialty. A judge may qualify for assignment in more than one area of specialty. To be eligible to be named on the list, a retired or former judge must have served as an active judge for at least 96 months in a district, statutory, probate, statutory county, or appellate court, have developed substantial experience in the judge's area of specialty. So the judge did not have listed family law as a specialty until after the motion was filed, and then he changed his specialty listing to include family law. But the motion was filed prior, according to the allegations in this writ for mandamus petition. I don't know if this is true. You don't know if this is true. That's why the appeals court needs to hear it. Whether the trial court acted improperly when it refused to allow petitioner to testify while acting in a pro se capacity and thus denying him the constitutional right to due process. During the hearing on May 20th, 2021, the trial court refused to allow petitioner to testify as to the best interest of his children. When asked by Mr. Long if he could call himself as a witness, Judge Snipes told petitioner, "You can't call yourself to the stand, but you can make all the argument that you want to make." You know, I'll accept that. It's just not testimony. See attached excerpt from the court hearing of May 20th. This is a complete denial of due process and thus a denial of his constitutional rights to the same. Further, and this, by the way, this is the hearing in which the judge issued every single order against Michael Long. But he didn't allow him to testify, allegedly. I have this transcript. It's about 200 pages. This is complete denial of due process and thus a denial of his constitutional rights to the same. Further, the court made a ruling without hearing from one of the biological parents, and as such, making a ruling without said testimony is a failure to determine the best interest of the children. I agree. You have the ability. He's in court. He's present. You have the ability to allow him to testify properly before the court. They don't take the testimony. They definitely don't have a full factual record. They definitely don't have the best interest of the children. Again, whether or not he will win is a different question. But that is certainly a violation of parental due process. If you have, like custody cases, they break all of the rules. They give the parents so much deference. You know, you can default on a custody case in Minnesota. You can not show up. You can completely default. The court can issue all sorts of orders against you. They can say you never showed up, you didn't care about the kids, all that stuff. You show up one time and say, yo, sorry, I didn't make it. And the court has to hear you out because it involves a change of custody, the stripping of custody and control of your own children. Custody court is not like other courts. You can recover from the worst mistakes in custody court because the right to your own children is so essential to human beings. Whether the trial court erred when it conditioned the payment of $15,000 paid by Michael Long on whether petitioner has contact with the minor children made the basis of this suit. At the hearings that were held on May 20th and July 7th, there was no testimony whatsoever as to costs or any related expenses associated with the case and whether Mr. Long had the ability to pay them. The trial court awarded expenses associated with the case to respondent and required Michael Long to pay them, even though there was no testimony that was elicited by any witness that evidenced any such related expenses. So they say, okay, you're ordered to pay expenses related to the case. But they don't know what the expenses are. They just ordered $15,000. They subsequently didn't ask if he was able to pay those. A fact matter on whether the judge should issue the order. Because if a party is unable to pay a listed expense and the judge issues an egregious expense ruling, that may be a sign of bias, that may be against the ability of the court to do so. It may be inherently prejudicial against a party, especially when you consider that they're going to condition Michael's ability to see his own children on the payment of these funds, which is illegal in Texas. But even if it weren't, they were going to make that a condition, and they didn't take down evidentiary information. Again, according to Michael Long here. The trial court awarded expenses associated with the case. Yeah, no testimony, blah, blah, blah. Trial court went on further to condition the payment of said expenses to petitioner's access to the children, specifically stating that he is required to pay $15,000 or, quote, the no contact period will be extended until such time as Michael Long appears before the court at a hearing he himself schedules to provide sufficient evidence as to why the court should lift the no contact order. The court is demanding $15,000 from Michael Long to lift the no contact order. See page 13 of temporary order in suit to modify parent-child relationship. Section 153001 of the Texas Family Code states that a court may not render an order that conditions the right of a conservator to possess of or access to a child on the payment of support. Now, the question is whether or not that $15,000 is support. I would argue that it is. Of course I would, if I were his attorney. If I were Kelly's attorney, I would argue that this is not support. This is a court award. But you've got two problems there. Whether guardian ad litem appointed for the children acted outside of her statutory role. Judge Michael Stipes, sua sponte, that means on the court's own motion, not on motion of either party, immediately appointed John Helms and Stephanie Cole Martin as guardian ad litem in this matter, and they both readily accepted the appointment, even though both attorneys have little to no experience in family law. Again, you have a highly publicized, extremely volatile case involving complex family law questions, and the two guardian ad litems appointed do not have family law experience. Alleged by Michael. Maybe they do. You have a judge with no family law experience until he changed it. Here we go. Texas Family Code 107.001B2. Let's look that up real quick. Let's get an accurate read of what that says. One 107.001B. That's an improper citation. That is not correct. What is he looking for here? Got the wrong site. What is his thing? Let's see. Yeah, I don't know. This looks like the wrong citation here because I cannot find what they're looking to do. Yeah, so that looks like a bad site. I'm not sure what he's after there. Couldn't tell you. Let's see. So there's no agreement between the parties regarding this appointment. Specifically, as to Ms. Martin, she is a criminal defense lawyer from Dallas County and lacks child advocacy experience. It is important to note that at the time that Judge Snipes appointed the amicus and guardian ad litem attorneys, he had a previous working relationship with both attorneys in the criminal law setting. At the time of the hearing on May 20th, 2021, Ms. Martin participated in the litigation of the case, calling witnesses and arguing to the court, which is outside of her role as guardian ad litem. So she is not maybe saying she's not the attorney ad litem. She's the guardian ad litem. Because they're different. There's an amicus attorney, an attorney ad litem, and a guardian ad litem. Let's see. Specifically, the Texas Family Code sets out the powers and duties of guardian ad litem as follows. Powers and duties of guardian ad litem for child. A guardian ad litem appointed for the child under this chapter is entitled to attend all legal proceedings in the case, but may not call or question a witness or otherwise provide legal services unless the guardian ad litem is a licensed attorney who has been appointed in the dual role. Whoops. It is clear that Ms. Martin was not appointed in a dual role, and after the court was notified that she was acting outside of her role, he continued to allow her to do so. That's a problem. That's a problem. No, Evil Bunny, I trust me, I looked at the code. There isn't a 107.001B at all. It doesn't exist. So he's looking at something else. But I'm not sure what it is that he's looking for. So Looks like, I mean, there are additional duties of attorney ad litem for a child in section 107.004. So who knows? Again, I don't know. I'm not here to do his legal work for him. I don't know the correct citation, but that one's missing something. That's it though. There it is by Michael Long. Then there's the verification of the petition. That's him stating who he is. This is based on his personal knowledge, and that's done. What were they scared of? What sensitive private information are they scared of there? Why was it so critical? What invasion of privacy occurred? Anyone want to tell me? Now, there's a bunch of attachments. There's a bunch of attachments. Like that testimony that I was reading to you earlier. That testimony that they don't want to talk about. This one right here. Which might have to come another day, because it is getting late. What's Kelly Long's side of the case? That she's... Both parents' side of the case are the same. The sides of the case are the same. We are not a danger to the children. Each of them asserting that. I mean, that should be obvious. Cars in depth. No, this one actually was testimony. This one right here, this is the July hearing. The 520 hearing that he's talking about is this one. 20th day of May, 2021. This is the one where he was not allowed to testify on his behalf. But at this July hearing, he did. This is what all this was. This is testimony. This is direct exam. The judge even referred to it as direct exam. Judge may have realized that he really screwed up by not allowing him to be called as his own witness there. Yeah, Spectre, I was waiting for you to send it to me. To say. So the email from Laura Elkin to Spectre says, I received an email tonight telling me that a screenshot of an email I sent to you today showed up in a Sophie Long Facebook group. I assume you had something to do with that. Spectre replies, yes. I provided the entire conversation between us without cherry picking anything. That is within my right to do so, which it is. I better bring it on screen. Otherwise I'll be called a liar or whatever. So here we go. There it is. So as stated, I mean, that's fine. That's just for completeness. I don't really care about that email. It doesn't mean anything. She's not like acting improperly and asking about that. But that is where we are in the Sophie case. That's the petition. That is what they're threatening people for. But listen, if you want to know what's going on, you want to know the truth about what's going on, it's pretty simple. Why do you want to suppress anyone else talking about a case? You say it's for sensitive information in the document. Clearly, in the petition, not talking about the attachments, but in the petition itself, there is no sensitive information at all. All of that is either legal argument or already extremely public knowledge. It is not overly graphic. It does not contain anything that would offend the sensibilities of anyone. It's just what it is. Now, again, in the attachments, there can be some different stuff. That's a different question. But in that document, there isn't anything. But if you are sending threatening letters to stifle the speech of anybody that is not under your control or influence, why do you do it? Doesn't matter if the information is good for you or bad for you. I already said the answer. It's not under your control or influence. When you pay tens of thousands of dollars, however much it is, for a PR firm to help control the media narrative, you can't allow alternative media to develop an alternative narrative. And by the way, do you think it's any shock that I can do this right now? Have you heard about the Sophie Long case in the news anytime recently? Any of you heard about this case in a while? I mean, if you're not specifically following it, and I'm talking the news. Sophie Long, father Michael Long accused of child abduction. Father who made viral video of his daughter making abuse claims is now suspected of kidnapping her. That's not true. Missing Sophie Long, 10, sent coded notes to dad during COVID lockdown saying she was in danger, blah, 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 15 hours ago. Sophie Long, girl, 10, center of Stand With Sophie campaign abducted after child sex abuse 1 day ago. Texas girl was centerpiece of viral abducted 2 days ago. Previous to that, 2 weeks ago. But that's not her. That's someone else. Where's the Sophie Long stuff? Think that's suddenly these news stories just got it. Suddenly they just came up with it. Weird. Hold on 1 second. There may be an update to something. If you found it in the Discord, send it to me in Discord or something. I don't know where you are. I checked streaming. I don't know where that is. Hold on, I'm waiting for it. So let me briefly address the kidnapping allegations. Okay, here we go. Yep, Discord did find it. Let me I think I can just pull it up from my existing. Where the hell did I put it? Here we go. Looks like he has a scrivener's error where he has an inappropriate. Well, he has a 0 where there should be a 1. And this is not typically a problem when it can be discerned that this is the intended section. Considering there isn't a section where he cited. Here we go. 107.011B2. Mandatory appointment of guardian ad litem, except as otherwise provided by the subchapter, in a suit filed by a governmental entity seeking termination of the parent-child relationship, or the appointment of a conservator for a child, the court shall appoint a guardian ad litem to represent the best interest of the child immediately after the filing of the petition, but before the full adversary hearing. Section B. The guardian ad litem appointed for a child under this section may be an adult having the competence, training, and experience determined by the court to be sufficient to represent the best interest of the child. So it can either be a charitable organization composed of volunteer advocates or an individual volunteer advocate appointed under subchapter C, or an adult having the competence, training, and experience determined by the court to be sufficient to represent the best interest of the child, or an attorney appointed in the dual role. We found out that the attorney is not in the dual role. Let's see. Then that's evident because they appointed 2. So here we go. The court may appoint an attorney to serve as guardian ad litem for a child without appointing the attorney to serve in the dual role, only if the attorney is specifically appointed to serve only in the role of guardian ad litem. An attorney appointed solely as a guardian ad litem may take only those actions that may be taken by a non-attorney and may not perform legal services or take any action that is restricted to a licensed attorney, including engaging in discovery other roles than as a witness, making opening and closing statements, or examining witnesses. So it's going back to that section. So thank you to the Discord for finding that very quickly. But there we go. Tom Riddle says, but there is the issue of the missing poster put out by the Texas government. Okay, what I was going to say in disputed child custody cases. By the way, Kelly Long's attorneys know this. Guaranteed. In disputed child custody cases, the police will not, absent an explicit order, recover from a biological parent a child on behalf of another biological parent. And those orders are really, really rare and explicit. Now, I think one of those orders may have issued in the July 14th hearing. That may have happened. Was it July 14th? Was it July? Hold on. July 21st. Was that July 21st? Really? No, 7th day. Sorry. 7/7/21. My bad. July 7th. They may have issued that order there. It's not entirely clear. I don't have a subsequent order from it. I just have the hearing itself and the oral order. So we don't know exactly what it says. The judge reads the order to the court, but then one of the attorneys adds a motion to modify some of the language. So that being said, and I can tell you from experience, representing a parent whose child was taken across state lines, held against the orders of the court, you cannot get the police or the FBI to act on these things. Even if you know exactly where the child is, they can't do it. They won't do it. They won't get involved. They'll say, get a court order. Get a court order. We're not going to do it. it's very, very frustrating. It's very, very frustrating. But what anyone can do is file a missing persons report with a county law enforcement agency. Missing persons reports can be filed by literally anybody on the planet. And then there's a missing persons report. There you go. So, let me just remind you, one of these people is allowed to talk about the case on social and other media, and also has a PR firm. So if you are trying to generate public sentiment on behalf of your PR firm client, what do you do when one parent is in possession of a child and you allege that it's wrong? You issue a missing persons report. Of course you do. Because you have to remember that Kelly Long's case is being fought in public. Michael Long should do the same. But he's been slapped by the court before for trying to do that. Kelly's been allowed to do it as much as she wants. This is a basic concept. If you have the ability to control the narrative, you take the ability to control the narrative. If Kelly were my client, I would too. That being said, it's just important to remember that this is all a narrative. This is a narrative. Kelly has a PR firm doing this for her. It's a narrative. Their job is to control this narrative. There's so many people out there who switched sides. They were on Michael's side because they saw that Kelly was found by the court to be a danger. By the way, pretty sure Kelly's still considered a danger. Like, she didn't win custody of Sophie. Her sister did. Kelly's not allowed to see her because Kelly's considered a danger. But yet, Kelly's fully in support of it going to her sister. Also important that there is no evidence that exists right now that any child at any time has been hurt in the care of Michael Long. The reason the court determined that Michael Long was not fit was an argument about something called parental alienation. Let me get a handy dandy primer on it because it's not that simple. It's not a simple concept. Here we go. Parental alienation in a Texas child custody case is, in a formal sense, parental alienation happens. I'm stealing this from the Little law firm down in Texas. Little Lyttle, because it's a summary on the subject. In a formal sense, parental alienation happens when one parent intentionally manipulates the child or children to cause him or her to reject the other parent without a valid cause. In many cases, a parent will vilify and demean the other parent in front of a child, causing him or her to share the feelings of hurt and anger, which then strains the relationship between the child or other parent. So what the allegation is that Michael did that to Sophie to cause her to create a fictitious story about her mom and her mom's boyfriend. A boyfriend with convictions, a boyfriend who is alleged to have engaged in several domestic assault actions while the children are present against the mom. So the claim The claim is that Michael Long did that. The court found that in the hearing where Michael Long was not allowed to testify. So again, I don't know. I don't know Michael Long. I'll probably never meet him. I'll probably never talk to him. If he dies tomorrow, I won't ultimately care. I mean, I'll feel bad for family members, for the kids and all that stuff. But other than that, makes no difference to me. If he wins custody of Sophie or doesn't matter to me. Kelly wins custody of Sophie or doesn't matter to me. I want the children to be safe, whatever the truth is. That's the only thing I would care about in this case or any other child custody case at all. I want the children to be safe. However, I have a problem. I know that in the care of Kelly Long, she violated a court order and it directly resulted in harm to one of the children. I know that happened. What I don't know is any instance where when Michael Long violated a court order that harm occurred to a child. I don't know that. No one has ever shown that. No one has shown that in court. No one has put it down in testimony that Michael directly caused harm to any of the children at all, much less while violating a court order. So that being said, I want the children to be safe. I don't particularly care about Michael Long. He's made so many decisions that I disagree with in his marriage, in his subsequent marriage, in his personal life, in his legal case, in the publicity of all of this. He made decisions that I disagree with. If he's the wrong guy to be the parent to the kid, take him away. Take him away immediately. But I don't know that. I don't know that he's wrong. I don't know that Kelly's wrong. What I do know, though, is we have one side actively trying to obscure the truth while the other side is muzzled. They do it under the guise of the children's privacy. But I don't see any privacy issues in what's going on, especially when they've got a PR firm trying to control the public narrative about it. Tells me they're not interested in privacy, they're interested in winning. And they should be. You should be interested in winning your custody case. It should be the most important thing in your entire life, in my opinion. But don't lie to people. Marty says, so wait, the judge who was forced to recuse handpicked a bag man. His solution was to gag the dad, give the child to the mom's family out of state where she'll never come back, making the whole issue moot in Texas. I mean, I don't want to say it that way, right? But it kind of looks that way, doesn't it? Kind of looks that way. Okay, we've got a justice chat here from Kaylee's barren womb. It says, sorry for the chat vomit. Kaylee has been spewing in her chat. She's never been the same after her 5th abortion from having too many trains ran on her. She now copes with toffee and clinging to anything that gives her clout. Damn. That was a brutal justice chat there. Woo! So as far as the status of Sophie Long, presumably she is still with Michael. She is still quote unquote missing, although they apparently know that she's with a custodial parent who has an obligation to appear in court. Michael appears to be in violation of a court order to turn Sophie over. However, I have not seen that court order, so I can't assess the validity of that or whether he is actually in violation or not. I don't know. I don't know what the status is on that. If he's in violation of the order, and again, without having read the order, I can't even make a preliminary determination, but if he's in violation of the order, I would strongly urge him to comply with the order. Now, I have not read Michael's reasoning for not complying with the order. It's very, very, it's very, very slanted in his favor, and you guys know the reason. And by the way, I don't really want to get into it because it'll take me forever and I'll get really pissed off. But the judge and the opposing attorney, David Routson, want Michael to admit that he's violating the order. And Michael, being who he seems to be, is happy to admit that he's violating the order because he says, basically, short version, if I believed that violating your order would protect my child, then I would do it every single time. And as a dad, I can 100% sympathize with that. I get that. I understand that. But that being said, still may be violating a court order, and he may have just said on the record that he was violating a court order. Were they trapping him? Sure. It's a problem with being a pro se litigant. But you should not admit to violating a court order. And again, if Michael's violating a court order, he better hope his mandamus comes down. Cave Canum. I've been drinking the 1K shot. All right, guys. I think that's where we're going to stop for tonight. I've hit the main points I wanted to hit. I've hit that the judges in this case, the first two judges, who also appointed the third judge, were absolutely compromised. I've hit that the third judge has done some things in this case that are problematic. In regards to Michael's ability to testify and in regards that orders are issued. I've hit the fact that Kelly Long has hired a professional PR firm and has her lawyer, Laura Elkind, who is representing her but doesn't seem to be making appearances in this case, is out issuing cease and desist letters to people who merely want to discuss what's going on. I've shown the PR firm. I've shown the proof of the PR firm. The proof of the PR firm is the article that was issued by her attorney with the press contacts being from the PR firm. I have shown how it is plausible that this case is being lensed through a PR firm, that public perception has shifted by a group of people whose job and expertise it is to mold public opinion. And they seem to have done it very effectively to a bunch of probably well-intentioned but very gullible people. And I've also shown that Michael has severe problems in this case. That his behavior is not good behavior in family court and is probably hurting him in the long run. And I hopefully have shown, finally, that my ultimate interest is the children and their safety. But it's not like obsessive. I don't, at the end of the day, this is another case I'm talking about. I hope the children are safe. I hope the judges and the courts come to the right conclusions. I hope that the parents find peace and healing amongst themselves and each other. And all of this, it's important for both Michael and Kelly to know, all of the damage to your children, all of this is both of y'all's fault. It's rooted in a marriage with a weak foundation, with weak pillars, unwilling to come together and resolve issues, willing to let their partners go into the beds of other people, willing to let their partners betray the vows that they made to each other because they were frustrated, and an unwillingness to work on your own relations. You both have caused damage and injury to your children that is far beyond this case and far beyond repair. And may someday you reconcile that with yourselves and beg forgiveness at the feet of your children. That being said, guys, we're going to go ahead and finish up the super chats for tonight. And then we'll go over to Twitch, I suppose. I'm starving, so I got to eat something. Okay, so we've got start. Jay says, as a psychologist, what aggravates me as much as Ken getting fired is that his regular clients have to suffer because of lying, attention-seeking fats. Exactly. Exactly. The people who went after Ken took him away from people he was helping. Now they have to go to someone new. They have to get assign someone new they don't trust. They have to restart. It's a trauma. It's a trauma. Shield Ken's GoFundMe. I should do that. Here we go. Let's do this. This is important. Help Ken recover from targeted harassment. This is supportken.com will take you here. Supportken.com will take you to this. He does have a GoFundMe going right now. His goal is $10,000. Here's the full link, but you can go to supportken.com to make it easy. Not legal advice, but do you feel like he has a case for filing an ethics complaint? Absolutely. Absolutely. Spectre, that's not my donation. That anonymous donation is not from me. I don't know who made that. I'm about to make my donation. As we all know, all anonymous donations are really just me. Yes, that's true. That's true. Now I will make my donation. I don't know who the big baller is. Here we go. Who takes more, locals or GoFundMe? With GoFundMe, you can have them take 0. GoFundMe, you can tell them to take 0. So if you want to support Ken like day to day, you can. Here we go. as is my policy, I will never ask anybody to contribute to something that I would not contribute to myself. I have pledged $500 here to Mr. Ken Jennings. He's already got some other donations coming in. We've got a $200. All of these are me, obviously. 1,200, 20, 10, 10. And then plus my public one of $500. You mean Locals, not GoFundMe? No, Locals does payment processing through Stripe. Stripe takes a portion of it. GoFundMe, you can set the portion that they take to 0. Or well, I believe they have a credit card processing fee as well. It's about the same. So, there you go, guys. Let's help Ken get through his transition of employment. The fat mads will never win, and they should never win. So, that being said, let me get back to the, we'll check in on that at the end of the stream. See if anybody else donates. Hopefully they will. Let's get back to the chats that have come in. Wrecker Wronghouse says, Nick, did you know about Twitter testing out a downvote button? Because they are. Oh, I can't wait. It's interesting, and I was just curious about what you think of this. Good. Also, what do you think of being a part of Omo Live, a group founded by the fart streaming cat girl Omo? I have no comment on Omo Live or the farts that accompany it. That one guy says, children are safer if the public knows what the courts are doing with them in their family situations. This idea of keeping everything sealed is ridiculous. They could be putting these kids in unsafe homes and transing them for political favors otherwise, which one of the judges, Ray Wheelis, in this case, has actually done in the Save James case. E1337 Neo says, Nick, have you ever heard of Judge Frank Caprio, whose judicial work is televised on the show Caught in Providence? Nope. Unlike most judges nowadays, he has a heart and bends the rules a bit to give breaks to people who need them. I'm not particularly aware. I may have seen something about him. But if you say the name, I don't recognize it. Next, we've got Santiago says, hey, Kaylee with the T, you're fat. You are old. You are useless with a barren womb. Put away the peanut butter and apologize to the cat. Get back in the kitchen. Dang. That one guy says, does this porky bitch think hiring a PR firm and trying to get people fired from their jobs makes her look like a zealous mother protecting her child? Because to my estimation, it makes her porky ass look entitled. These idiots kind of deserve each other. I don't know what she thinks. Jane Doe says, as Trump, Nikki, thank you for covering Sophie's case with these crooked attorneys and judges. People deserve to know the legal facts. To Ken's doxers, they're not just doxing, they're doxers. This is their life. This is state of being. It's what they are. Look, frankly, it's sad. I've seen this before. You've seen this. You walk around, you're like, oh, I'm mingling with polite society. You know, people who are mechanics, grocery store employees, fast food employees, people I love, by the way. They make me chicken that I ride around in my jet with. I love these people. I love everybody. Love everybody. But you're walking around, you're like, oh, wait, there's some doxers. Can't trust those people. Can't do it at all. Can't trust them. To the Ken's doxers, you whales are extremely unattractive. Nobody wants to be with these people. Who would want to be with these people? Disgusting. Disgusting. Inside and out. Fuck you. Also, Nikki shares legal facts, not your BS fuckery claims. Thank you, Jane Doe. That one guy says, I just gave Ken $10 on his GoFundMe. Do better than me, chat. They took a swing at this man's life by taking his job. They want him dead for speaking his mind. All of us are next. Let's say no to these assholes now. Let's get them. SupportKen.com. There you go. And we've got some other chats here. Lord Chippy Dip says, hey, Nick, have you heard about Blizzard being sued by the state of California? Yes, and we'll be covering it very soon. Trucker Rob, thank you for the donation. 5 Simple Words says, hey, Nick, just showing my appreciation and support for what you do. Shout out to Ken Jennings. Keep going hard at these duplicitous sirens. I'll catch the replay in the morning. Andrew Ward Snowboard says, don't be ridiculous, Nick. Your sheets know who the best custodian is. Mike Hunt says, the Riccio anime is free on YouTube at the moment. Andrew War Snowboard says, I have no idea why spellcheck says sheets instead of always, but I'm so mad at my phone right now. I thought sheets was funnier than always. That was great. Mulfiard says, you should email and invite Hogue Law on for the Activision lawsuit. He made a great hour-long dive into the documents today. Also, Big Nose, Best Nose. The gray one says, dear God, that vid was upsetting. Someone who has a lot of baggage since childhood. How can anyone can do that? Makes me shake with pure unfettered rage. My heart goes out to Sophie. Absolutely. Absolutely. David Edwards says, Google warned me that if I live chat, people will be able to see I subscribe to this channel. Yes, that's because I turned on subscribers only chat, which keeps the spam bots down a little bit. Uriah Wright says, this woman makes Casey Anthony Mother of the Year. PW says, trigeminal neuralgia is a suicide disorder, very degenerative, very painful, very no therapies. It's a horrible thing not to be wished on anyone. Damn. Funny Valentine 2004 says, or 2024 says, Jesus, the number of red flags in that relationship. Yes. ASO says, would you ever consider interviewing Rucka Ali? Yeah, anytime. I mean, I don't know. Rucka Ali was affiliated with Maddox for a long time, so I literally don't know if he has any like negative feelings towards me because I talked about Maddox's stuff. But I have no issue with Rucka. I think he's a funny guy, and I'd interview him in a heartbeat. Also, the reason people don't like Vic on Twitter is because they are fugly monsters, and then a chat emoji. Tom Bombethrill says, hey, we're paying you too, Grifter. Don't you forget. I never do. Fabian Torres says, Kaylee with the T is just trying to gain clout from trying to disprove you. Good luck. Everything I've said is backed by documents. It's all public. It's all available. The only person who doesn't want it available is Kelly Long and her attorney. I don't know what to tell you. I'll tell you every bad thing about both parties. I don't like either one of them particularly. I don't know either of them. So if Michael turns out to be a scumbag that harmed the kids, put him on the wall and shoot him. I don't care. I don't care. But fairness in court, especially family court, is critical. And this family court does not look to be fair at all. So Michael's harming the children. If Kelly's harming the children, put them on the wall, shoot them both. Don't care. Get out. Get out. She needs to go back to her garbage channel and one video that she's probably paid for bot subscribers and views. Trucker Rob says, theoretically, if I was to talk about this case, could I hire Ty's law office to send snarky responses to cease and desist emails? Theoretically, you absolutely could. Donut Swan says, Judge Pervert confirmed. Vacus Imago says, if the woman who doxed Ken is from England, doxing is a crime in England. Naughty, naughty. Nope. Canada and the United States. By the way, the people who went after Ken Jennings, yeah, they had that doxing mirror turned around on them real fast. Play stupid games, you win stupid prizes. Philibooty says Anna is only 76 subs away from 200K. That's awesome. Oh my God. Philibooty. That everybody should check out that Star Wars girl. Being only 76 subscribers away from 200,000. If you're not subscribed to that Star Wars girl, go give her a little boost. Get her over that 200,000 milestone. That's awesome. Here's what I honestly read when you sent that earlier. I read Anna thinking that you were talking about I don't think any of their names are Anna. I just kind of glossed it. I thought you were talking about one of the Fat Mads, and you were saying literally they were 76 subs, as in Subway sandwiches, away from 200 kilograms, as in 440 pounds. I thought you were making a fat joke about the fat man. That's what I thought that was. I hadn't even, like, I just glanced at it. I saw 76 subs, 200 kilograms. That's fucking funny. Oh, God. Okay. Shamu13 says, so is this child trafficking related? Not in the traditional sense that you would think of. Eric D says, Squishy is only 76 subs away from 200 kilograms. Oh, no, there it is. It actually exists. It exists right after it. That's why I thought it. See, it's not my fault. It was right after it. Joel Reese says, here's some more Griff coin for a job well done. Thank you. Angry Bellsprout says, what do you think of Mexico's soccer team getting fined over fans' offensive chants? Garbage. They basically call opposing teams F slurs in Spanish. It's hilarious. That's funny. Of course, the soccer team shouldn't be fined for that. That's not their fault. Jackson Kai says, my biggest problem with these cases is the main legal weapon. The safety of the children is generally completely disregarded at every turn. Yes, it's awful. Phantasmagorical says, thanks for this, Nick. Hashtag keep the kids safe. Marty Lund says, interesting part of this is the misconduct by lawyers, judges, and parties, not the custody and kid stuff. That's just sad. Dave Canham says, would you consider covering the trial of the couple who started the El Dorado wildfires with their gender reveal party facing 20 years? Sure. Is it going to be public at all? Mike Hunt says, after listening to this stream, I'm now Drexel pilled. Never get married or end up hiding in a corner of your house drinking and surrounded by 40K stuff. Oh, stop it. Funny Valentine 2024 says, left the stream for a bit, so I may have missed this, but is Sophie actually missing? Seems like she may be at the time. It's hard to say. Or is she just in with Michael at the moment and the NPR is a PR stunt? NPR being the missing persons report. She is with Michael, but I do believe they looked for Michael and Sophie at the residence and they're not there. So are they missing? I don't know. Maybe, possibly, but is it a PR stunt? Missing or not? Yes. Yes, 100%. And they're using this to build public perception against Michael. That is their goal. That is the most important part of the missing persons report. In my opinion. That's why they're doing it. Because they don't need a missing persons report to do this. Eric D says, what is more powerful elastic bands? Squishy's yoga pants or Ridge's wallet's slim RFID blocking design that holds 1 to 12 cards without stretching out? Squishy's yoga pants, even though the Ridge elastic is impressive. Nix Hex says, Rucka called Maddox a cuck on his own farewell stream for best debate or whatever it was called. I doubt he has any animus against you. Yeah, I literally don't know. I've never talked to him. I would. He's an interesting guy, makes funny songs. And then finally, Prophet of Truth says, when the great journey begins, the weight of your fatness will stay your feet and you shall be left behind. All right, guys. That's that. Let's see. Ken has, oh my goodness, we've got a jump in Ken's GoFundMe. Thank you to you guys. $2,275 raised from 25 donors right at the start of this thing. Let's, I'll be mentioning this in the next couple days. Let's get Ken some buffer room to help him get new employment and to provide some ease and comfort in his household. Losing a job is extremely stressful. Losing it because people lie about you is even worse. But as for now, that's the end of the show. Thank you all very much for hanging out with me. I'll consider doing more Sophie streaming in the future, but there's not a lot more to be said at the moment. If I discover something, I will talk about it. I'm not going to sit and wallow in this case like a bunch of sad old women do every single day. Again, I hope for the safety of the children above all else. And whoever harmed the children, may the worst fates befall all of them. All of them. And the courts and the guardian ad litems and the attorneys and the parents have done uncalculable damage to these kids mentally and emotionally on something that should never have gone anywhere near this far. But that's just reality. And to the chat, never be that fat, sad cat lady who can do nothing else but talk about some minor in a state you don't live in and act like it's your cause. It isn't. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plenty folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are.